You all ready? Good start. All right, good afternoon once again. I'd like to call back to order out from recess the Board of County Commissioners meeting for February 28th. This afternoon, I need a motion to accept proofs of publication.
Motion so moved to accept proof of publication. Second.
Motion Zembauer, second Delary. Any discussion? All those in favor say aye.
Aye.
Aye. Any opposed? Motion passes unanimously. So this afternoon, I'm going to read our rules of public hearing that we normally operate under. Our code, our rules of procedure that the Board of County Commissioners is operating under has some flexibility for the chairman to adopt timelines for public hearings such as this. And so I notified both the applicant and both appellants and some other members that were a part of an email thread that the following rules were going to be put into place for this afternoon's public hearing. So I don't know how many of you had these rules forwarded to you, but I'm going to read them so that we're all starting from the same perspective on the same page so that we all know what this afternoon is going to look like. Again, the Geneva Citizens Association, the applicant, and Bear Warriors United all received this last week. So,
Madam Chairman?
Yes.
For the record, I'd just like to clarify, the rules that you're going to be reading are rules that have been in our rules of procedure all along. They're just specifically pointed out, and you're reiterating what's already we have in the record and what we have in our operating procedures manual.
Yes, that is right. What the attorney said. It's in the blue binder. It's up here all the time. So here's how this is going to work this afternoon. Because this is a quasi-judicial hearing, we want to let you know that the board welcomes comments from all persons with an interest in the proceeding, and Florida law requires that the board's decision in a quasi-judicial action be supported by competent, substantial evidence presented to the board during the hearing on the application. Competent, substantial evidence is such evidence as a reasonable mind would accept as adequate to support a conclusion. There must be a factual basis in the record to support opinion testimony from both expert and non-expert witnesses. Persons presenting testimony may rely on factual information that they present that is presented by a county staff that the applicant presented, or on factual information included in the county staff report to support their testimony. All persons who present written materials to the board for consideration must ensure that a copy of the materials is provided to the clerk for inclusion in the board's record of proceedings and official minutes. Has any commissioner received any oral or written communication regarding the quasi-judicial items? If so, please disclose the substance of the communication and identify the person making the communication. We'll start at this end. Commissioner Herr.
Yes, I have received emails, I have received phone calls, I have taken meetings, and all of it has been turned over electronically.
Madam Chairman, I have also received meetings, phone calls, and emails, and I'll be submitting that electronically as well as in hard copy.
Madam Chair, I likewise have received phone calls, communication via electronic format, both in letter and email form, as well as met with some of these individuals, and those were all submitted via electronic format.
Commissioner Constantine?
I've had emails, meetings, phone calls. I've already turned them in electronically.
All right, and I also have had meetings, phone calls, and received emails that have been submitted electronically as well. So this afternoon,
Thank you.
our staff is going to make the initial presentation for items for consideration with a recommendation. The board will have an opportunity to ask questions of staff when presentations have finished. The applicant will have an opportunity to make a presentation, and it will be 15 minutes. And then the appellant will have an opportunity to make their presentation, which will be 15 minutes. Then we will have the opportunity for the public to participate. There is going to be an hour for each item for public participation. At 3 minutes each, that's 20 people to speak on each item. So here's what I would advise. If someone has spoken before you and has already said exactly what you're going to say, perhaps you don't want to use your 3 minutes to say the same thing. Perhaps you want to allow someone else who is speaking to use their 3 minutes, because when we get to an hour, if everyone has not spoken, That's just where we're going to end it. So use your time wisely, use your words wisely, because we will not be listening to repetitious comments. So pay very close attention to what the people in front of you have said, because if you're going to say the same thing, you are wasting time for other people who might have new things to say. So, members of the public that are interested in speaking either for or against, you have to fill out the yellow form. And by the time I'm done reading these rules, Ms. Beach needs to have that form in her hands for you to be speaking this afternoon. If you do not want to speak, if you just want your comments submitted for the record, I want you to fill out the green form, and those will all be passed down the dais to us so that we can read them. So when you come to the podium, I'd like you to state your name and address clearly for the record, whether you are for or against the item. We talked about the 3 minutes that you are being given, but you don't have to use them all. If you are an organized person speaking on behalf of an HOA, you will be given 6 minutes, but that means that the other members of your HOA are not going to have their 3 minutes to speak. You are choosing to have a representative speak on your behalf, and that will be that 6 minutes. In accordance with the board's operating policies and procedures, the Seminole County Board of County Commissioners, Section 2.175, Public Participation Before the Board, speakers shall limit their comments to the subject being considered by the board. All public comments shall avoid personal attacks, abusive language, and redundancy. Disrespectful, rude, irrelevant, or slanderous remarks or disruptive behavior may subject the individual to removal from the board chambers. The chairman may curtail repetitious comments. The clerk's office is required to retain documents, photographs, drawings, etc., that are presented to the board, so if you show it to us, please be prepared to leave it with the clerk. Once all of the speakers have been heard, there will be an opportunity for rebuttal if necessary. I will close public comment, and the matter will be given back to the commission. Following a motion and a second, there will be board discussion and a vote will be taken. Commissioners who do not cast objecting votes are considered to have voted in support of the motion. Is everyone clear? All right. Any other words from the attorney or the county manager?
Not at this time.
You reserve the right. All right. All right. Thank you very much. All right. So we are going to start this afternoon with our staff presentation on item 31, the Yarborough Ranch Preliminary Subdivision Plan Appeal from Bear Warriors United. And Ms. Moskowitz, before you start, I'm going to do one last call for forms.
Okay.
So if your form is still in your hand and it needs to be turned in, this is your opportunity to give it to Ms. Beach. She will not be taking any more comment forms after, yep, right, yep. Going once. All right, thank you very much, appreciate y'all.
Madam Chair, just
Yes.
just a question. Since we have two different appeals, is this for just the first one?
No.
Or for both?
This is
of
for
them?
the afternoon.
Okay.
This is for
So
items
I don't-
31 and 32. If
Okay, I
you
just
want to
wanted to make sure
speak on
that-
either item 31 or item 32, thank you for offering the opportunity to clarify. We want to make sure your comment cards are in. Okay. Thank you, Ms. Moskowitz.
No problem.
Madam Chairman, before she
Yes.
starts, just for further clarification, item 31, which is the Bear Warriors appeal, will be heard first and
Yes.
separately, and then we will go into the Geneva Citizens Association, which is item 32.
Correct.
Thank
And
you.
so I'm hopeful that on your forms, you indicated which item you wanted to speak for or both. All right.
You ready?
I think so.
Good afternoon. For the record, Mary Moskowitz, Planning and Development Services. Item 31 is an appeal of the planning and zoning approval of the preliminary subdivision plan for the Yarborough Ranch subdivision. The maps shown on your PowerPoint presentation are the same maps as those that are provided in your agenda packages. I will try to include the page number for each map that is shown on the screen. On December 7th, 2022, the Planning and Zoning Commission approved the PSP for the Yarborough Ranch subdivision containing 300 acres of residential, 300 residential lots on approximately 1,313 acres located on the east side of Snow Hill Road, approximately a quarter mile south of Old Mims Road. For background, in July 1991, in response to Seminole County's transmittal of its comprehensive plan, the Florida Department of Community Affairs made a finding that the Seminole County's land use policy for the Seminole County East Rural Area as general rule at the time of 1 dwelling unit per acre would encourage sprawl. Based on this finding, the Seminole County contracted with a consultant to prepare the East Seminole County Rural Area Plan completed in August of 1991. The recommendations in that study included the creation of the Rule 3, Rule 5, and Rule 10 future land use designation. The plan also recommended the use of cluster subdivisions that would allow the development of single-family residences on a minimum of 1 acre lots while leaving the remaining undeveloped property either as open space or for agricultural uses. The recommendations included the ability to have cluster subdivisions with or without the use of a density bonus. Based on these recommendations, the BCC amended the Seminole County Comprehensive Plan in 1991 to adopt the Rule 3, Rule 5, and Rule 10 future land use designations. The Rule 3 and Rule 5 land use policies include the provision for the use of cluster development on a minimum of 1 acre lots without the use of a density bonus. In the Rule 10 future land use designation, there is a provision for a density bonus. In general, lots are permitted at a density of 1 dwelling unit per 10 net buildable acres, or 1 dwelling unit per 5 net buildable acres are permitted if the units are sited on a minimum of 1 acre lots. Oops. In compliance with the future land use policies in 1992, the Land Development Code was amended and included the provisions for the optional cluster subdivisions in the A3, A5, and A10 zoning classifications. The A3 and A5 allow for the use of the cluster subdivisions with the minimum 1 acre lots with no density bonus. And the A10 zoning classification allows for the increase of density from 1 dwelling unit per 10 net buildable acres to 1 dwelling unit per 5 net buildable acres if 8 acres of open space are preserved for every 2 units. To utilize the optional cluster provisions, a development order and open space easement are required to be approved and recorded concurrently with the plat. As shown on the map, the Yarborough Ranch property has a split R5 and R10 future land use designation and a split A5 and A10 rural zoning classification. On February 12, 2008, the Board of County Commissioners approved a development order 07-055-0040, which utilized the optional cluster provisions as outlined in Section 30.109A of the Seminole County Land Development Code. The development order permitted the development of a maximum of 300 1-acre lots on the subject property. Per Section 3513E4 of the Seminole County LDC states that the decisions of the Planning and Zoning Commission to approve a preliminary subdivision plan may be appealed to the Board of County Commissioners. Staff has received 2 separate appeals. This appeal is from Ms. Katrina Shaddix on behalf of Bear Warriors United. Per Section 1.12 of the Board of County Commissioners, appeals shall be heard de novo. The appeal from Ms. Shaddix claims that the 2008 development order on which the Yarborough Ranch PSP was based was improperly conducted and not properly approved by the BCC as required by state statute. All applicable sections referenced in the LDC, reports, and statutes have been included in your packets. The second appeal from the Geneva Citizens Association claims the PSP violates the requirements of the Seminole County Comprehensive Plan and Land Development Code. A detailed presentation of those claims and subsequent staff findings will be discussed at the next presentation. This map provides the overall site plan for the Yarborough Ranch PSP and shows all 3 tracts that are included in the Creekside Acres plat. The Seminole County issued a development order 070550040 on all 3 tracts known as Creekside Acres, which is approximately 6,406 acres. The DO provided for a perpetual open space easement to be executed encumbering approximately 1,017 acres of upland on tracks 1 and 2. And tracks 1 and 2 are that middle tract and then that other tract towards my right. This easement was recorded on February 13th, 2008. Furthermore, the entirety of the 5,057 plus or minus acres of tract 1 and 2 are currently owned by the St. Johns River Water Management District and are currently utilized as an open space park. This information was presented to the P&Z Commission at their December 7th meeting and is included in the P&Z staff report, which is included in your agenda packets. Per Section 30.109A of the Land Development Code, developments that utilize the optional cluster provision require an open space easement and development order to be adopted simultaneously with the plat. The code specifically requires a development order, not a development agreement. Development agreements fall under the statutes, Florida Statutes 163.3220. Those statutes are included in your agenda packets. Again, as stated earlier, Creekside Acres is a development order. The plat for Creekside Acres, the development order, the open space agreement were approved together at a public hearing on February 12, 2008. The BCC meetings are noticed in accordance with Sunshine Law and Florida Statutes 286.011. The agenda and minutes from that meeting are included in your agenda package. Per LDC Section 1.12C, appeals of the decisions of the BCC are subject to the term of Florida Statute 163.3215. This section states that the appeal must be filed by a petition of writ of certiorari filed in a circuit court no later than 30 days following the rendition of the development order decision of the local government. The appeal period for development order 07055000040 has passed and no appeal was filed. Staff finds that the Yarborough Ranch PSP meets the applicable development requirements of the Seminole County Land Development Code and the Seminole County Comprehensive Plan. Therefore, the decision of the Yarborough Ranch PSP approval by the Planning and Zoning Commission should be upheld. Noted this morning, staff received an email from Ms. Shaddix with a hydrological report prepared by Peter Borelli, PhD, and I apologize to Dr. Borelli if I mispronounced his name, because I just got the report this morning. This report appears to reference a plan that has been withdrawn by the applicant. This concludes my presentation on this appeal. However, please note that my presentation for the second appeal of the Geneva Citizens Association will present an analysis of the claim made by that appellant that the PSP failed to comply with the provisions of the Seminole County Land Development Code and Comprehensive Plan. Again, this presentation was specific to the appeal by Bear Warriors United on the development order. I'm happy to answer any questions that you may have.
Yes, we do have a question.
Yes.
Could you please explain in a little more detail what you were talking about, that there was something that was withdrawn?
So there was a plan that was submitted by the applicant to utilize a water treatment facility that went to the Planning and Zoning Commission, but before it went to the Board of County Commissioners, that plan was withdrawn. There was also a pre-application, I believe, that may have shown half-acre lots. That application was never submitted as a public hearing.
Okay, thank you for that clarification. Any other questions for our staff at this point? Mr. Zembauer?
I want to make sure that I get some clarity, and this is going to be for our council. We've heard talk about the development order, and if I'm understanding what staff has said, and I think I understand what the statute indicates, the time to bring in question the development order has come and gone. Is that correct? 30 days after the February 12th, 2008 hearing?
That is correct.
So we should not be considering anything related to a development order at this point? This is strictly the PSP?
Correct. The development order was created and adopted by the Board of County Commissioners in 2008. It was not appealed at that time. And the next step according to Section 30-109, is to move forward and to plat the property with the individual lots. And the first procedural step in that is to go for a preliminary subdivision plan, and that is the stage that the applicant or the property owner is at now, which went to the P&Z, was approved, and that has been appealed, and that's the issue before you.
Understood. Thank you.
Any other questions? All right. Thank you very much. All right. We'll hear from the original applicant.
Thank you, Madam Chair and Commissioners. Mr. Gray, welcome to Seminole County.
Thank you.
My name is Rebecca Wilson. I am here on behalf of the owners and James W. Yarborough serving as trustee. I really appreciate staff's thorough report, and I just can't help myself, while this map is up, the magnitude of the amount of property that was saved in 2008 for this county is substantial. So just for those in the audience who may be joining us for the first time for these discussions, as Mary pointed out, the middle piece of property is shown as Tract 1, and that runs along the econ. In fact, it extends over the econ buffer protection areas, the 550 and 1,100 feet. Then Tract 2 runs along the St. John's. When the Yarboroughs came to the county in 2008, and it was the county and the Water Management District, they owned at that time 6,399 acres. Uplands, so when we're talking about net developable, how many houses you can build, the upland amount that they owned, the net buildable acres, were 1,819 acres. What they did in 2008, based on the plat that you see being recorded, the development order that went along with that plat, and by the way, that development order was in its entirety in the staff report and the materials that were reviewed when this plat was approved. On all of that, the Yarborough family has conveyed to the state 5,057 acres. And in 2008, the decision that was made is that they would retain 1,300 acres. Let me make sure I got that right. Yes, 1,341 acres. Of that, 466 are wetlands, and the net buildable is 800 acres. And the decision was made in 2008. And by the way, we've gone back, we've rerun the math. Mary talked about how you can use the density bonuses. They would be allowed today to more than 300 units, but they agreed in 2008 to 300 units. We have used the cluster plan in order to achieve those 300 units in a PSP that meets all of the county's criteria. The Yarborough family is not asking for a comp plan amendment. The Yarborough family is not asking for a rezoning. What they have done is simply apply the rules that are in your comp plan and code, and they have demonstrated to staff how they can, consistent with the 2008 development order, meet all the rules for a preliminary subdivision for 300 units. And just a couple of things about a quasi-judicial hearing that your attorney alluded to, and that is you have to consider competent substantial evidence. So what is competent substantial evidence? Well, I'm a lawyer, so I can't actually give you competent substantial evidence because I'm not an engineer and I'm not a planner. I'm just really good at talking in front of people, right? But who can create competent and substantial evidence is John Townsend. He's our engineer. He's in the audience if you have any questions for him. And he works for Donald W. McIntosh and Associates. They submitted this preliminary subdivision plan on July 1st, 2022. So staff didn't just take this PSP and rubber stamp it and move us along to the planning and zoning. No, in fact, we have gone back and forth with your staff responding to their concerns and comments and requests for more information until mid-November. At that time, we went to the Planning and Zoning Commission. The other thing you can consider as competent and substantial evidence is your own staff. You have a staff of professional planners and engineers whose job it is to review the material we give them and render to you a staff report, which Mary presented to you all today. They have years of experience in applying, interpreting, and in many cases being the ones who actually drafted the policies that come into play with approving a PSP. And they've rendered an opinion. In fact, your Planning and Zoning Commission rendered the same unanimous opinion, and that is that the preliminary subdivision plan for the Yarborough Ranch is consistent with the Seminole County Comp Plan, Seminole County Land Development Code, and the 2008 Development Order. Madam Chair, I'm happy to answer any questions that you have, but I'd like to just keep any time that I may need for rebuttal.
At this point, you have 10 minutes left out of your 15 that were allotted.
Thank you.
So I'm going to go ahead and pause the timer. Are there any questions?
No, at this time.
Doesn't sound like we have any right now. Thank you. All right. Bear Warriors United, as the appellant, you have 15 minutes to present to the board your appeal.
Katrina Shaddix, Executive Director, Bear Warriors United, 1011 Seneca Oaks Trail, Geneva, Florida, 32732. On behalf of Bear Warriors United, I am appealing the 12/7/22 Planning and Zoning Board approval of the Yarborough Ranch preliminary subdivision plan. I will be referring to several documents today. One is by Dr. Peter Burrell, and it's entitled The Hydrogeology of the Yarborough Ranch Development, Problems with On-Site Sewage Disposal. That was actually emailed to the county this week and about 6 weeks ago, and previously about 5 weeks before that. So y'all have had it several times, but I'm going to be referring to it today because it does make a couple really good statements. And Dr. Burrell is here, should you have any questions about his excellent work. But one of the statements in his paper says the proposed residences with high density, the Yarborough Ranch development, will pollute 27 to 43 million gallons per year of effluent via septic tanks into the underlying drinking water aquifer that is protected by the Geneva Freshwater Lens Protection Act of 1993. Septic tank effluent from these 300 residences will result in nearly 5 tons of nitrogen pollution per year, in addition to human fecal bacteria, viruses, synthetic compounds, into the protected Geneva freshwater lens. His paper also states that it has been recognized that an additional 300 drinking water wells would threaten the Geneva freshwater lens. Some other documents I may be referring to today would be an article stating that septic tanks play a major role in algal blooms. And in that article, it also says that the legislature and the governor recognize that septic systems are one of the leading sources of pollution in many water systems in Florida and need to be addressed. At this time, when our governor is making huge investments to do septic to sewer transitions, we definitely don't need to be putting sprawl development in the rural boundary that will add another 300 septic tanks. That may soon be prohibited, maybe by the end of this year. Another document I may refer to is Attorney Chipaw's handwritten notes that support my argument of the development order, and I can refer back to those, but he did watch the 2008 Seminole County Commission meeting. He made handwritten notes, and I can get to that later. Another document I may refer to is, I think the rest of them are in your folder. Did y'all get your folders, purple folders? One is the legal analysis. That will be the major part that I argue. Another piece is information on the crested caracara, which is a federally protected species that lives on the proposed subdivision site of the Yarborough property. And the final is an article from 1990 entitled Ranch by Econ Reunites Sisters, Divergent Paths. The last sentence is highlighted for y'all. It states, while they are unsure how their children and grandchildren will feel about the property, they know one thing. They do not want to see the rolling 3,000-acre ranch turned into a subdivision. I think that was the last page in your purple folder. Okay. Now, and then, I think this was also emailed to y'all. The last thing I would refer to before I go into the main part is that I have worked very hard for the past year to secure funding and to secure a state agency that would buy the Yarborough property and put it into conservation. They are a willing buyer. Hopefully, the Yarboroughs will be a willing seller. We want the Yarboroughs ultimately to make a lot of money and to put this land in conservation. Nobody wants to cheat them out of money, but I think that's a win-win for everyone. So know that that is our ultimate dream to happen today. Not all of this arguing, but we need to get this done and out of the way. All right. Based on a legal analysis, the 2008 development order was found to violate Florida law because it was approved with no public hearing or notice of any kind. And because the 2008 development order is unlawful, all subsequent entitlements obtained for the property are unlawful, including the preliminary subdivision plan approved for the Yarborough Property Ranch by the Seminole County Planning and Zoning Board on December 7, 2022. The factual background is that the 2008 development order is recorded as an official record of Seminole County. Former Seminole County Commission Chairman Brenda Carey signed the development order, the 2008 development order. The date she signed it is missing from that document. The official records provide that the development order was filed with the clerk of court on February 13, 2008. On February 12, 2008, a Seminole County Board of Commissioners meeting was held. A county staff report recommended BOCC approval of the Creekside Acres final plat, which is now known as the Yarborough Ranch. The report makes no mention of whether a development order will be heard and voted on by the BOCC, much less whether staff recommended acceptance or rejection of a development order for the subject property. The BOCC meeting minutes for February 12, 2008, which is in your papers. Consent agenda item 14 addresses the recommended approval for the final plat for Creekside Acres. The meeting minutes and videotape of the meeting establish the following facts which occurred in sequence. Agenda item 14, Creekside Acres final plat, was included in the consent agenda. The minutes provide Commissioner Delary requested that item 14, approval of the final plat for Creekside Acres, and item number 17, approve certificate of public convenience and necessary for air methods, be pulled for a separate vote. This discussion is confirmed by the videotape of the meeting. The minutes provide Commissioner Henley stated there is quite a debate about increased density in order to cluster. He stated when this was approved, he never dreamed that it would be set up as a subdivision in a rural-protected area. He said he still has problems and reservations regarding this because they are giving them a 1-to-1 ratio rather than a 1-to-5 or 1-to-10 ratio, meaning one house for every 5 acres or one house for every 10 acres. Chairman Carey stated this issue will come forward for development approval sometime in the future. She said the board is only authorizing the chairman to execute the final plat. The videotape confirms a discussion among the commissioners about the clustering and density on that portion of the property that was not put into conservation. Chairman Carey stated at several points in the video that this was not a vote on the development order. At 27 minutes and 7 seconds, Carey reiterates that the vote is an action to authorize the chairman to do the final plat. So we will see it, the development order, again. The videotape reveals that at 35:34, the BOCC voted unanimously to approve items 5 and 14 on the consent agenda. A verbatim transcript of the videotape at 34:58 through 35:35 provides, this is a conversation Carey says, we will be looking for an approval then from item 5, 14, and 17. Delary, Madam Chair, with 17, we are asking for that to come back, correct? Carey, no, I think we are just given direction to, as he moves forward, to look at that level of service, and as all these come up for renewal in June of this year, to make that one of his items he's going to be looking at. Then Delary says, can we vote on these individually then? Carey says, certainly. Does anyone have a problem with combining 5 and 14? McLean says no. Carey says, looking for a motion to approve 5 and 14. Delary and others, so moved, approved. Carey says, all right. Any discussion? All in favor signify by saying aye. BOCC says aye. Carey finalizes saying opposed like sign, move to approve 17 with comments from the board and direction as these continue to come back, as they will all be back in June. Now, yet the minutes explicitly contradict the commissioner's spoken words during the meeting. The minutes incorrectly state that the BOCC unanimously voted to approve and authorize the chairman to execute the final plat for Creekside Acres located on Snow Hill Road. And Section 3, Township 21S, Range 32E, Lou Tolt for Yarborough Ranch Properties, and approval of the development order and open space easement as shown on page blank. These minutes do not accurately reflect the actual videotaped BOCC discussion. When the vote was called on item 14, the videotape reflects that there was no discussion of approval of the development order and open space easement. Indeed, there was never any discussion by the commissioners at the BOCC meeting of open space easement. This videotape confirms that the BOCC had already decided and agreed that the development order would not be a part of the vote on the agenda item 14. Once again, I note that the staff report for the February 12, 2008 BOCC meeting only addresses the Creekside Acres final plat. Staff recommended approval and did not discuss the merits of any development order, much less the 2008 development order that Chairman Brenda Carey signed and recorded as an official record. The discrepancies between the videotaped meeting and the meeting minutes are significant. There is blatant incongruity between what is actually discussed by the BOCC during the meeting in connection with the development order for Creekside Acres and the inaccurate minutes. The incongruity, coupled with Chairman Carey's signing of the 2008 development order and filing it as an official record in absolute contravention of her overt statements, at the meeting stating that no development order would be voted on raises concern that due process was violated. What really happened in connection with the 2008 development order? The videotape establishes that 4 of 5 BOC members were misled in some manner. When they voted to approve item number 14. The facts thus unearthed established intentional concealment to get the 2008 development order quickly accepted, signed, and filed without BOCC debate and vote. Multiple public records requests established that there was neither public notice nor public hearing conducted by Seminole County in connection with approval of the 2008 development order. Nonetheless, Chairman Carey unilaterally signed it. There is no indication of when she signed it. There is no date, no seal, no notarization of her signature. Presently, Florida law requires notice and hearing for a county agreement to a development order. The same was true in 2008 when Chairman Carey unilaterally signed the 2008 development order. In 2008, the development order was signed. Section 163.3215 Florida statutes provided in relevant part, the local process must make provision for notice of an application for development order. The local process must provide for a clear point of entry consisting of written preliminary decision at a time and manner to be established by the local ordinance. And then the local process must provide an opportunity for participation in the process by an aggrieved or adversely affected party, allowing reasonable time for the party to prepare and present a case for the quasi-judicial hearing. This simply did not happen with respect to the 2008 development order. There is no record of any sort of notice and hearing in connection with its acceptance. Affected Seminole County residents could not know about this 2008 development order because they were kept in the dark. They were denied any opportunity to object to 2008 development order to the BOCC. This is unlawful. Seminole County Land Development Code, Chapter 20, governs development orders. As in 2008, the LDC continues to fail to provide any basic hearing and notice procedure governing issuance of development orders. Indeed, the LDC absolutely circumvents public participation.
Ms. Shaddix, you have about 2 minutes remaining.
Oh, I do? Okay. I was confused there. So let me wrap up by saying, I'll just conclude, and y'all have the full argument there. So in conclusion, both the 2008 development order and Chapter 20 of the LDC, which governs development orders, are unlawfully flawed. Chapter 20 fails to provide any procedure for effective public participation in the comprehensive planning process by failing to require notice and hearing before a development order is accepted. The 2008 development order was unlawfully accepted because there was no notice and or hearing opportunity before Chairman Carey unilaterally signed it and filed it as an official record of Seminole County. Because the 2008 development order was unlawfully accepted, all subsequent entitlements granted in connection with the Yarborough Ranch are tainted, including the preliminary subdivision plan approved for the Yarborough Ranch by the Seminole County Planning and Zoning on December 7, 2022, and now on appeal. That's all. Thank you.
So here's, yes, absolutely. If you'll give me 1 minute to just address something. So for the rest of the afternoon, there are going to be people who say things you like and people who say things you don't like. Just keep it to yourself. If you want to do a thumbs up, that's great, but clapping takes time, right? So we're trying to minimize time. So I'm good with thumbs up. That gives us an indication that you're on board with whatever was just said. Yes, Ms. Wilson?
I just want to make sure that the audience and Ms. Shaddix understand the consequence of what she's asking for. So I agree with Attorney Chippuck that now is a bit too late to come back 15 years later. I mean, whatever is done, 15 years later. But if you take away the DO, we are not limited to 300 units on this property. If you take away the DO, and believe me, guys, I've done the math. This is what I get paid for. We get 360 units. So if you guys want to get rid of the DO, the only purpose of which was to limit Tract 3 to 300 units. The plat is done. She agreed. Plat's done. I just want to make sure she understands exactly what she's asking for.
All right. Thank you, Ms. Wilson. And so we're going to move. We can move to snaps. We can do whatever you want, but the longer you prolong, the less time you have to convey the things that you would like this board to hear. So we are going to start with public comment, unless the board has questions of Ms. Shaddix at this point. Mr. Zembauer?
I think I have questions of Dr. Borelli.
Okay.
As an expert in this matter, I'd like to have a few moments to inquire.
All right. That's certainly within your rights to do that. If you would, please, your name, address, and title for the record.
Good afternoon, Commissioners. I'm Dr. Peter Burrell from Palm Bay, Florida, in Brevard County. And do you want to start with the question?
Yes. I'm looking at, this is your work product?
Yes, sir.
And tell us a little bit about that work product. First, let's start with your training and background.
Sure. So I have a PhD in environmental sciences from Florida Tech in Melbourne, Florida. In fact, I recognize Commissioner Constantine. He and I served on a Florida Senate task force on fertilizer use in the environment here in the state of Florida. So good to see you, Commissioner Constantine. It's been several years, but he and I have worked advising the Florida Senate on environmental policy in the state.
And are you a licensed engineer?
Sir, I'm a scientist, not an engineer.
Okay. So what kind of work and scope of work have you done to arrive at your opinions in this document? And can you give me the methods and the formulas that you use to arrive at your opinions?
Sure. I looked at some of the reports done by the engineering companies, the Water Management District, and production of the project plans for the tract of property.
Anything else?
Well, other than the fact that I'm a professional at arriving at analyses, I certainly looked at the DEP's reports and the state of Florida reports on this area.
Understood. So I think what I'm hearing is you relied upon others' work product to arrive at this based on things you've read and reviewed and so forth by other experts.
As a professional, we absolutely get ourselves acquainted with the body of evidence that supports the background information on any topic, and that's a routine thing to do. In fact, if you look at the end of the report, you see references of that information that I used.
So can you give us an idea of the method, scientific method or formulas that you utilized to come up with this information? Not what you read from somebody else, not what you relied on somebody else to do, the actual methodology to arrive at these opinions.
Sure. So, for instance, there were, I believe you referred to a estimate of water disposal by septic tanks on 300 homes, and the nitrogen concentrations and loading as a result of those. So I actually used the Florida DEP's equations and methods from Seminole County, so they're very credible in terms of those estimates.
That's it?
Well, sir, other than the fact that I have a PhD, I'm an expert on septic tanks and loading.
Understood.
Yeah. That's
I
important.
don't question your PhD. I know a lot of people that have PhDs that
No, the point is that
can't find their way around their own bedroom, but my question
Folks, listen.
question is...
All right,
Okay, just to clarify.
ladies and gentlemen,
clarify.
excuse me. I'm going to stop you for one moment. The board is requesting professional interaction from our public, and we are going to offer the same. No, I don't need your help. I got this. So we'll just move forward with that in mind.
So you haven't done any actual work yourself other than what you're relying upon DEP?
That's not correct. So I actually did formulate those opinions of discharges and loads, and so all those calculations, all that work was what I did based on good background information from the Florida DEP.
All right, approximately how much time do you think you spent reviewing that to arrive at this, including drafting this report?
Probably weeks.
And are you being compensated for your work?
Sure, I'm a professional environmental consultant.
That's all I have, thank you.
Thank you so much. You can have a seat. Any other questions for any other members? No? All
Good
right.
to see you, Commissioner Constantine.
Thank you so much. Ms. Beach, if you would, we will start with public comment. Can you tell us how many speaker forms you have for this particular item?
10.
Okay. All right.
The first one is Kim Buhite, followed by Leon Flowers, followed by Leslie Blackner.
Okay. And if all three of you would make your way forward and just line up along that wall there under whatever those paintings are. I can't see them from this angle. And that way we'll be able to move through to each person. So the first person was Kim Buhite.
Yes, ma'am.
All right. You'll have 3 minutes.
Thank you. First, sorry for the hat. I'm working today. I have hat head, so would you rather see this or me wearing the hat? Take your pick. Anybody?
It's your call.
Your call.
Kim Buchheit, speaking for myself and my family. Mark Edson and Claire Buchheit Edson, 252 Spring Run Circle, Longwood, Florida. I'm submitting competent and substantial evidence. There'll be some paper handed to you, so I support Bear Warriors United appeal. My family and I support the appeal, and we agree that the original development order was flawed and should be reconsidered. In addition, we recommend that Seminole County consider the loss of conservation value of the remaining developable property, which is Tract 3 of Creekside Acres is platted. I can show you that if I can put up materials. Is this working?
Yep, it should be.
You can see it on the map. It's up there, Tract 3. Maybe by the time that is ready to roll. I'll just...
And if you would like to use the microphone that's there, if you would like to point to something that's on that paper, you're welcome to, and that way folks that are watching can also see your finger pointing.
I think I'll stay put. I'm kind of comfortable here now. So, Tract 3 is in the heart of the rural boundary and is surrounded by conservation and recreation lands. Little Big Econ State Forest surrounds this property. These are public information pieces of paper. And on the top, that shows you Tract 3 of the plat, and there's an oval red circle down below on the lower map, and that is nestled right within the confines, the boundary. It's contiguous with the boundary of Little Big Econ State Forest. So just to put that in perspective from the standpoint of conservation, there's many articles and scholarly studies on the subject of conservation value and fragmentation of habitat. And just to skip ahead, you're going to have these articles in your hand. They are by either peer-reviewed sources or educational entities like Stanford University, Nature Conservancy, and they are credible information. You can review them. But the gist is that significant research has documented the importance and effectiveness of maintaining corridors and buffers to prevent wildlife habitat fragmentation. In the state of Florida, in fact, we're recognizing and prioritizing wildlife corridors for acquisition for these same reasons. And I would suggest and submit that it's important to do that locally as well, and take a look at the corridor that's being interrupted here, and make sure to carefully consider the configuration of any development that happens on this tract if it can pass the test of having a valid development order.
And I will just remind everyone that we've heard from the attorney that the development order is not what we are here to talk about today. That is not appealable.
I'm sorry, I didn't hear you. Did you ask me a question?
No, I did not.
Oh, okay.
But thank you very much.
Thank you. Do you want my qualifications, by the way?
No.
Okay, thank you.
Next speaker, please. Name and address for the record.
Leon Flowers, 890 East State Road 46, Geneva. I've lived in Seminole County for 45 years and 47 years as a resident in Florida, 25 years in Geneva. Therefore, I think I can speak for a lot of us that live in Geneva. I am sure the board is aware that there is a housing development already plotted in Geneva on the corner of Cemetery and First that is owned by the Yarboroughs. It has 80 home sites. I would think this should be developed before other land resources are rezoned. Our last storm showed how low the proposed development is in Snow Hill and was flooded and was closed to traffic. Anybody that lives in Geneva can attest to the fact that all it takes is one load of dirt placed in the wrong location can change hundreds of acres. An example of this is Taylor Lake, which is on Route 46 across from Lake Proctor Preserve. Up until a few years ago, this lake had a drainage path. Someone made land changes that has stopped the lake from draining. This has caused hardship to more than one family living on a lake which overflows in residence yards in the area. All you need to do is go to the Lake Proctor Preserve and look at the topographical map, and you will see that Taylor Lake would drain during the dry season. If the Yarborough Ranch is approved, will this be just another Seminole Woods? Or will the ranch benefit all income levels? I believe if this ranch is approved, there must be at least 20% of the housing be designated as low-cost housing. I also know that the impact fees associated with building a new home, this is a county fee. Here in Geneva, it would have a direct effect on the Geneva Elementary. Will there be additional funds designated to develop the developer to improve the school for additional students, and that will impact Geneva Elementary, real buildings, not porter schools? Rural Seminole County was designated as a buffer to stop urban sprawl. All you need to see is how fast Seminole County has grown, both in new housing and traffic. Geneva was set aside just for these reasons, that Seminole County believes in preserving Geneva and its wetlands, which benefits not only Geneva but Seminole County as a whole. Thank you for your time.
Yes, anything that... Thank you. Unless anyone has any questions? No. If you would, Shani, please read the next three names.
Leslie Blackler, followed by Callie Adams, followed by Joe Humphreys.
Hello, my name is Leslie Blackner, 300 South Duval Street, Tallahassee, Florida. I'm the attorney who wrote the legal memo for Bear Warriors United. And I just wanted to clarify one thing.
Objection, I'm sorry. Bear Warriors United has already had their 15 minutes.
I would like to make a comment.
Let me confer with our attorney and make sure that we're following the procedures that we said we were going to follow. I just want to make sure that we're being fair to everybody.
There's a distinction. Is this person speaking as a citizen or as a representative of Bear Warriors?
It sounds like if you are legal counsel and representing Bear Warriors, that their time has been used for their presentation.
Well, I'm also a member of Bear Warriors United, and I did my legal analysis for free, I might add. I have a deep interest in this issue. I wish to clarify a remark that was made by Mr. Chiphock, which is completely inaccurate regarding this particular development order.
Okay, I'm going to ask you to stop for just a moment.
There was no notice
I'm going
in
to
hearing.
ask you to stop for a moment because we don't have the clock running and we have not yet determined whether your testimony is going to be considered under public comment or part of the Bear Warriors appeal. So,
And again, I think it goes back to the individual, whether she is giving us citizen comment or whether she intends to represent Bear Warriors. So I can't answer that question.
Okay.
That is on her.
So you then have an option to decide if the testimony that you are going to provide for the next 2 3/4 minutes is going to be of your concern about this item, not as a representative of Bear Warriors. This board is happy to hear it.
Thank you. Thank you very much. I'm speaking for myself. I wish to clarify that the development order was signed by Brenda Carey without any notice and hearing. We have the YouTube tape that shows this. We have the tape. The bedrock of Florida law is that there must be notice and hearing before a land use change is made, and that applies to development orders. The memorandum that y'all received cites cases that says that the 30-day clock that runs to give a citizen an opportunity to object to a development order doesn't kick in if the citizens don't have notice and hearing. The people here have been completely denied their most basic rights to notice and hearing. That is the whole bedrock of our land use jurisprudence. And that's why this whole thing, this whole replatting, this platting has been a sham. It really is. And I say this as an individual, a citizen, and as an attorney. Thank you.
All right, we appreciate your time. Ms. Adams, and who was behind Ms. Adams?
Joe Humphreys, followed by George Sellery.
Mr. Humphreys, Mr. Sellery. I think Ms. Adams may have stepped out with the baby, so we'll let her speak. We'll put her at the bottom of the pile. So Mr. Humphreys, Mr. Sellery, and we'll come back to Ms. Adams if she returns to the chambers. I think that was who walked out. Can anyone nod? Maybe.
Yes.
It's okay. We'll come back to you, Ms. Adams. Yeah.
Good afternoon, all. Joe Humphreys, 883 Cardinal Point Cove, Sanford, Florida. I'm here as a concerned citizen and somebody with experience in farming and real estate investments. And I'd like to try to add some context to this whole history. I certainly believe and support the comments that were made this morning's session by Commissioner Zembauer about protecting our rural heritage and our farming. It truly is a major problem. I'm quoting from an article that's entitled Seminole Ranchers See Way of Life Fade. This is dated March 12, 2001. And it states in here, in '97, Ed Yarborough sold his development rights on about 3,400 acres of the eastern side of the property along the Econ and the St. Johns, which we've seen. The deal prevents housing or commercial operations, with the exception of cattle operations, until 2017. Development is additionally restricted by special buffers along the Econ River. The ranch also sits far outside the county's boundary for urban development. The area lacks essential ingredients for large-scale development, which includes dense zoning, high-capacity roadways, and central and water and sewer. The county's growth plan specifically targets the area for nothing more than rural development, or homes sitting on 5 to 10 acre lots. Now, that will probably be the last domino people will have to worry about, said Chuliota resident Susan Courage. I think that the land is very important to that family. I think it is. And I think at this time, it's safe to say it's relatively safe. I would like to see 10 or 12 generations on there. In 2004, this county, these people voted to do just this, to protect the rural boundary. That's what it says. And as you can see, maintain current densities and intensities in the rural area. I won't go back to what Mr. Henley said at the time, but that's exactly what he was concerned about. He understood that there were issues with this whole development process. And as you've heard before, it was not brought to a legal conclusion. Thank you.
Ms. Adams?
Thank you. For the record, my name is Kaylee Adams. I live at 1011 Mockingbird Lane in Geneva. I have to make this quick because I actually need to leave early to go pick up my kids from Geneva Elementary. My concerns are as a parent and as a fifth-generation Floridian and lifetime resident of Geneva, or Seminole County, or Seminole Eastern area, specifically Chiliota and Geneva. So the area is very important to me. I'm concerned about the schools, and an influx of students for 300 homes would definitely strain the system. Staffing is already low in teachers and in transportation services, and I just don't think that it would be wise to add that many students to our schools right now. It would be a burden to Walker Elementary, Geneva Elementary, and Lawton Childs Middle School specifically, probably Jackson Heights as well. Those would directly affect my children. Another thing that would affect my family in particular, and all of the Geneva citizens who rely on the freshwater lens for our drinking water. Not everybody is on the Mullet Lake Water Association or the Lake Harney Woods Water Association. I am on a well. My drinking water comes from the aquifer. There have been times where we've had saltwater intrusion during droughts, and that is a big concern. If you add 300 wells that are atop of the aquifer, in fact, the Yarborough property sits directly on top of the bubble. That would be negligent to the environment and our natural resources. I'd also be concerned about wildlife interactions because it's such a green area. It could be a wildlife corridor, but we could see an increase in human-wildlife interactions at people's homes, vehicle strikes, which would cause property damage, loss of life, and traffic issues. I'm in support of the appeal. I guess I should have said that to begin. Both appeals, I would like to speak as I support both of those. And that is all. Thank you.
Thank you. Mr. Sellery is next, and Ms. Beach, who are the next several speakers?
Kathy Register, followed by Jonathan Amon, and then the last one is Cindy Holler.
Good afternoon. My name is George Sellery, and I reside at 5231 Shoreline Circle in Sanford. I've listened to a lot of this today. I like some of the things she said. Magnitude of this project. Magnitude of this. Can't think of too many things bigger than the 2000 and the vote back then and the river cross. This is right up there, top of the line. I never saw public hearings. Everything was consent agenda. Different story. Also, like experts, staff is an expert, attorneys are experts, although attorneys never always agree. So they don't even need the citizens or you, because they're the experts and they are always right. So I want to start with some of that. I'm a math expert. Budget director for Sheriff Esslinger, budget director for Sheriff Vogel, deputy county budget director in Volusia County at one point in time, wrote the DeBerry feasibility and corporation study. The math. So let me give some math on this. This property, they got paid, according to the records, and maybe I'm wrong, but the records showed $30 million for the sale of the property to the St. John's Water Management District, of which, on the record, shows 2,864 acres are listed as wetlands, and 1,156 acres are listed as sovereign, which has to do with water and the high water mark. I'm not an expert in that. Those figures add to 4,020 acres that were essentially, from the reading, unbuildable. So only 1,017 acres are considered upland acres and therefore buildable for $30 million. And I applaud them for getting that. That land will forever be in conservation. But if you get $30 million for 1,017 acres that now belong to St. John's, how can you then transfer these acre credits, density credits, to Tract 3? How does increasing the density of Tract 3 from 172 buildable lots to approximately 300 lots, that's from the St. John's Water Management District memo dated September 11, 2007, help the rural area retain its rural characteristics? Who provides the essential services for this? Section 30.1088 talks about density credits. That memo from St. John's quickly basically said the retained property would be enhanced by shifting development rights onto it from part of the property to be acquired. Seminole County staff has indicated that shifting development rights from parcels 1 and 2, and I don't think many of them are around today, onto parcel 3 is consistent with the comp plan. This shift is part of the strategy authorized for the plan for clustering. The result will be an increase in density from 172 units to 300. So again, the math kind of doesn't add up, and I never saw anything anywhere transferring the density according to the way the code reads. Thank you.
Thank you, Mr. Sellery. Next speaker?
Kathy Register.
Hello, my name is Kathy Register, and I actually live in Winter Park, Florida. I have lived here since 1953. Needless to say, I've seen a lot of changes from the small town that I started out in Orlando, with the sprawl that has continued over and over and over. So I would like to cite from an article that may pertain nationally, but I say it pertains to where I am today. The article is called Vanishing Open Spaces, Population Growth and Sprawl in America. Cities were built where the best farmland and water existed. As cities and towns grow, they sprawl outwards over this prime farmland. This is where 85% of development sprawl happens. Over a third of the land that has been developed has occurred in the last 25 years. If we keep paving over cropland at this rate, it will all be gone within 200 years. That may seem like a long time, but it's not. As it is, there isn't enough land to grow more than a fraction of the biofuels needed to replace diesel fuel. And with land vanishing from development and topsoil loss, that's an empty hope for the future, for my kids, my grandkids, and our future generations. Thank you.
Thank you.
Jonathan Amen.
And Ms. Haller, if you want to make your way up, you're up next, I believe. All right, thank you.
Hello. Good afternoon, Chairman, Commissioners, and to the folks representing Pruitt. Good afternoon to y'all. Jonathan Amon, 1437 Bayhead Court, Orlando, Florida. Retired, coaching youth soccer, volunteering at the local school for literacy program, concerned about Florida and its development trend. Growing up in rural nowhere, North Carolina, I can tell you what a septic tank failing looks like. It isn't initially noticed, except by the homeowner, when it doesn't have to be pumped out so frequently. But over the course of weeks and months, the soil above it becomes wet and sogged and filled with weeds. What does one septic tank do to the water quality of the surrounding area? I'm not sure. But imagine 300 septic tanks being flooded by the inundation that we suffered as the results of Hurricane Ian. It was unprecedented. It wasn't even forecasted. National Weather Service had no idea that it would produce this much rainfall as it did. I think if this development goes through, we could be putting people in harm's way. They're not even here yet. They're probably moving to the state. The last census, we had 320,000 folks move to Florida between 2021 and 22. And where are they going to live? 300 units with what they're looking to build here isn't going to satisfy the housing needs of the struggling low and middle income families all across Florida, and especially here in Central Florida. This proposed development is in the very heart of the central portion of Florida's wildlife corridor. We can barely keep 100 panthers here in the state. This area is also designated as a high, not a high probability, but it is home to the Florida black bear. This is a central part of its habitat here. Hopefully y'all see them in your yards in the afternoons and the mornings. And lastly, the law doesn't prevent me from mowing my lawn at 7:30 on a Sunday morning, nor does it prevent me from shooting hoops till 1 o'clock in the morning. But I don't do that because I respect my neighbors and my community. Just because the law allows for something to happen doesn't mean it should happen. I'm fine with 300 units, but where? Not here. It's not going to do anything to improve the quality of life for the people around this place. I mean, there are people sleeping in cars in Walmart shopping centers. And where's the logic in the developer creating a community as they tout on their website if this is going to set the precedent or act as a catalyst to destroy the very community that we have here now? Thank you for my time.
Thank you. So we're going to move back to the applicant for rebuttal.
Thank you, Madam Chair. Just quickly, I didn't hear any competent, substantial evidence that there was any particular comprehensive plan future land use element or any land development code that was not met with this PSP. For those of you who are familiar with the comprehensive plan and its requirements for development in the PSP, you know that I believe Mr. Burrell's, both his testimony and his paper are quite irrelevant considering we're complying with the rules that exist now in the rural area, which is you cannot have a central water or sewer system. Just one more thing. I'll tell you that actually the only thing that's come up that I heard that is part of what your staff considers when we're putting together a PSP is school concurrency and school availability. And so with regard, I pulled out my paperwork with regard to the elementary school. There are enough units, there are enough student stations for this project and 59 additional capacity there. So I just wanted to let them know that we have, and your staff has considered all of those things, and at the time of final plat, we'll not only have to pay our school impact fees, but we'll have to meet concurrency. Happy to answer any other questions that you all may have.
Commissioners, questions for the applicant?
Thank you.
All right. Before we go to any other questions, I did want to ask the county attorney to address the issue of the original development order and its validity.
Yes, thank you. For the record, Paul Chipok, Deputy County Attorney. And, okay.
Ask
For
you
the
to
record,
speak right into that microphone.
right into the mic.
Oh, yeah, as close as you can get without it being uncomfortable would be great.
Okay, just like when I'm up on stage singing.
Yes.
For this, I would really like to ask a couple of questions to either Mary or Rebecca, our planning staff. Section 30, the original development order was part of the process that took place in 2008. When was Section 30.109 adopted? The section under which it proceeded.
It's an excellent question.
For the record.
Oh, I
Have
don't
to
know
get
if
them to
those
turn the
mics are on.
mics on out.
So for the record, Rebecca Hammock, Development Services Director, that section of the Land Development Code was adopted in 1992.
Okay. And Section 30.109, and correct me if I'm wrong, is not a rezoning. It is a section that allows the clustering of units on property.
That is correct.
And it requires that at the time of the plat, the open space easement and the development order in relation to how the property is being clustered has to be adopted in accordance with the plat, correct?
That's correct. That section of code requires that a open space easement and the development order be recorded concurrently with the final plat. And just for clarification, the project also had a preliminary subdivision plan, a PSP, that was approved on February 6th, 2008 by the Planning and Zoning Commission.
Okay. So again, when the plat was approved, as part of the plat and as reflected, and the plat is incorporated into your document package and the plat recording number is Plat Book 74, page 1. It does specifically reference that the development order is incorporated, and it cites the OR book and page of the recorded development order, and it also references the open space easement that was adopted and recorded in the official records at the same time. So under Section 30.109, the three items, the plat, the open space easement, and the development order are part of a three-legged stool. In order to transfer the densities from the open space parcels, the sending areas, to put them on the receiving areas, that is, all three of those documents are required. Under our under our Land Development Code, which was adopted in 1992, and also that section was not challenged and was reviewed by DCA at one point and approved as being consistent with our comprehensive plan.
Commissioners, questions?
Mr. Chipak?
Yes, sir.
Have you closed public input?
I have not. I have not. Yeah. Do you foresee any reason to not close public input?
The discretion is yours. If a burning question comes up that you would need it to be answered by somebody, you can reuse.
Okay. We'll close public input then at this time. Thank you.
Mr. Chairman, Madam Chair.
Yes.
Ms. Chipak, I think the question was about the development order. Is the development order a proper order that was filed correctly? That's the question.
In my opinion, yes.
Commissioner Herr, ladies and gentlemen.
So can you give a little more information about how your opinion was formulated? Because I feel like we're in a situation where we've had, whether you consider yourself representation or not, the letter I'm looking at is representation, that goes into a fairly amount of detail that you clearly have a difference of opinion, and so we probably need a little bit more of that for the record.
Yes, the process that was utilized was Section 30.109, which allows for the clustering of units. So no new units have been created in this area to the 300 units. They existed over the original 6,000 acres, have just been clustered and taken from the sending areas, tracks 1 and 2, and placed on track 3, the receiving area. And again, the methodology that was done was through the plat, the open space easement, which reserved the open areas, and the development order, which showed the math and reflected that. And now that development order is not a rezoning. It is part of the platting process in this situation. And it did come before the Board of County Commissioners as a plat, including the necessary parts of the three-legged stool, which is the plat, the development order, and the open space easement. All three were in the record before the board and in the agenda package. And it was brought up, and in regards to the comments and my notes that are in there, I think I should clarify that. I was looking to see what arguments were made during the discussion. But discussion is just that. Discussion among the board members is just that. It's discussion. It does not, unless it is specifically incorporated into the motion is whatever the board decides at that time. If they think some of the discussion needs to be incorporated into the motion, it is your prerogative to do that. In that particular case, there was no discussion, there was no amending of the motion for approval that was in the agenda package. The board in 2008 just adopted the motion as requested by staff.
And was the meeting properly noticed?
Yes.
And there was also an allegation that the document was not appropriately signed because it wasn't dated, but the last line in the document in our packet and included in here is dated as of the first date noticed in the top of the document. It's just a different format. The date's not at the bottom of the format, so I'll answer that one, although I'm not an expert, so I'll turn that back over to the expert. I learned today I'm not an expert at anything.
If you look at
Neither
your...
are you, from what I hear.
If you look in your agenda package at page 446, which is the signature page of the development order, it is signed by Brenda Carey. Right above her signature, it says, "Done and ordered on the date first written above." If you turn back to page 444, it says, "On February 12, 2008, Seminole County issued this development order relating to and touching upon the following described property," and it lays out the Yarborough tract.
And that is indeed, by my review, the same document that was included in Ms. Blackner's letter as well. So I appreciate you answering those questions. Thank you.
Any other questions from the board? Any other additional information from staff that you'd like to share?
Sure. The Chapter 20 within the Land Development Code outlines the approval process for development orders, and we have different types of development orders within the code. There are development orders that require board approval. There's ones that can be approved by the Development Services Director. So not all development orders have the same hearing process or the same type of approval. In this instance, it wasn't a public hearing because it wasn't a rezoning action or a comprehensive plan amendment. It was a development order that was associated with a final plat to put forth how the clustering provisions were going to apply to the property.
Thank you. I think that's important clarification. All right. We have come to the end of public comment. The applicant and the appellant have made their arguments. The applicant has had the opportunity to rebut. We are now at that time where the item comes back to this board to make a decision.
No further discussion?
I'm looking for a motion and a second so we can have discussion. I think
As a district commissioner, I will move to uphold the planning and zoning approval of the preliminary subdivision plan for Yarborough Ranch subdivision containing 300 residential lots on 1,313.64 plus or minus acres, zoned A5 rural and A10 rural, located on the east side of Snow Hill Road, approximately quarter-mile south of Old Mims Road.
there's a motion. Is there a second?
Second.
Motion and a second. If there's discussion at this point, that would be Commissioner Constantine?
Yeah, Madam Chair, in life there's laws and then there's common sense. And the one thing that I recognize here is what we're doing is subsequent to what happened in 2008. And I think the real need here is that the Yarboroughs want to and have the right to sell their property. And there are opportunities here to sell that property. So, we've got two different appeals going on. I know we've got a second one. I'm not prepared to make a motion at this time.
There already is one.
I know. I'm not prepared to make a different one at this time. What I'm suggesting, though, and I will suggest at a later date, I think that there's a real opportunity for us, the county, to pursue the opportunity to purchase this land in conjunction with the state, being that this is in the middle of the wildlife corridor. The state is providing hundreds of millions of dollars to purchase it. If the county has a conservation program in place, which we are going to be discussing in a couple of weeks, and the fact that there are other opportunities to get different regional organizations involved in purchasing of this property. I just had a quick discussion. It's not the first, and it probably won't be the last, with Conservation Florida and Tracy Dean, who is the executive director of that there is a real opportunity to keep this property in conservation and work with the Yarboroughs on the purchase of this land. And I think the fact of the matter is that we can turn down this appeal and bring up the next one, and I think that's what we're going to do. But at the same time, that the common sense here is that whoever wins or loses, we are going to go into court. Both sides have already indicated that they are going to appeal the decision in discussions with them in our ex parte communications. And the fact of the matter is that I think that there is a better, as I said, instead of the legal, the common sense is that we try before either side goes into court a period of time that we can put together with our county manager and other people in trying to pursue the purchase of this property. And so right now we have a motion in front of us on this appeal. We're going to go up to the next appeal, but I think that is, if the Yarboroughs want to sell their land, which I know they do, and we want to do the best we can to protect the rural boundary, which I know we have all voted to do that, and that we understand that the appeal process is going to go on and on, that the common sense tells me that we should look at a chance to work and give a period of time, put things in abeyance, and try to find a way to purchase this property.
Commissioner Constantine, there's a lot to unpack there. Ladies and gentlemen, that is not why we're here. So I'm going to recognize Commissioner Herr, who is asked to be recognized, and then Commissioner Zembauer, who is asked to be recognized, and then Commissioner Dolari, who is asked to be recognized. Commissioner Herr.
I think we're here in a quasi-judicial meeting to discuss the topic of the appeal, not to discuss future agenda items, which I think is something that you're bringing up, quite frankly. And I would also tell you that I appreciate you bringing it up because I do think it would be wise for us to consider it. It seems as though there have been several conversations that have happened that have not been brought before this board. And so what I would say also falls into the common sense category is that if we're going to entertain the idea of making a significant investment on behalf of the taxpayers of this county, then those discussions need to happen on this dais, but not at this time. So I would, I'll defer down the dais, but I would be prepared to call the question once we hear from my fellow commissioners.
Commissioner Zembauer and then Commissioner Dolari.
Thank you, Madam Chair, and thank you, Commissioner Constantine. We are here today on an appeal process. We're not here to talk about future agenda items. We're not here to talk about what-ifs, how comes, maybes, and all those types of things. I think it's no secret, we find ourselves sitting here today because of a decision that was made in 2008. We have the inability to overturn a development order. The fact of the matter is this family had rights. They were granted those rights. They were memorialized in 2008. They have the right to move forward. And I think we would all agree it would have been fantastic if the state at the time when they purchased the other portions of the ranch that actually make up parts of the forest that people now are concerned with actually were part and parcel of this ranch and not for the Yarboroughs wouldn't even exist. So now they're being penalized because they made that deal and not be able to move forward. I don't disagree. We may and should have a conversation at a later date if there is a will to consider purchasing this with other partners. And I think that's the will ultimately of the family, that they would love to see this ultimately stay in perpetuity of not being development and be conservation. That said, they have rights they need to preserve, and that's why they're here today. So with that said, I'll look forward to calling the vote.
Yeah, well, we're going to let Commissioner Dolari have his piece, and then we'll do that.
Thank you, Madam Chair. I remember back in 2008, I remember that day, not word for word, but I can remember it in general terms. I did not look at the tape. I don't look at any of the tapes of past meetings. I think it does your best not to look at the past, so to speak. But I do remember that day when we were discussing it, and what was discussed was those 3 tracks that are shown up on the board there. And what was done back then was that we shifted over development rights, as staff talked about, so that the property of the 2 remaining tracks would be cost-effective for the state, St. John's agency, to purchase them. Otherwise, they were too overpriced. So we moved over those development rights to the one area.
Point of order. I'm sorry, Commissioner Delary, but I'm a little uncomfortable with the conversation at the other end of the dike. No. So I'm just getting us all back in the same meeting. I am so sorry to interrupt.
That's all right.
you, but
Don't worry about it.
Thank you.
We're good. So I remember, I'm just going to repeat myself for a moment.
Have at it.
So I remember us talking about moving the development rights from the 2 eastern part of the tracks over to the western part, so that it'd be more cost-effective for the family to actually sell them to the state. And that we talked about development rights, about bringing it down to 1 acre per unit. Then we talked about how that would work out. And I remember that I spoke about maximum amount of units because I didn't want engineers and attorneys, and please excuse all those engineers and attorneys that are in the room, because there's all ways of calculating things. I wanted to make sure that there would be a maximum amount of units that we'd be looking at, and that's how the 300 unit popped up. That's what I remember. And then we talked about how this would come back in the future. Did not remember or even think about how many years that it would take in the future, i.e., 2023, here we are. It's amazing how time moves on. But I do remember that when we talked about this, we did get letters from the community. Everyone wanted us to do it back then. I remember talking to Richard Credence. I know that we're going to hear from him in a moment, that everyone was in favor of it. Everyone thought it was a good idea. Everyone wanted to make sure that we preserved as much acreage as we could out there, and that's the reason why we did it. I don't think anyone, and again, I didn't watch the tape, but anyone talked negative about it. That's what I remember about that day. About buying the Yarborough piece, I believe that that's not what we're here to discuss. We did bring that up a month and a half ago, if my memory strikes me right. I'm not getting that old, but I do remember that. And our attorneys basically told us at that point that until the appeal process is over, and I think it was Mr. Chipok that said this, and I'm paraphrasing again, Mr. Chipok, you warned us and said that we shouldn't be talking about purchasing the property until the appeal process was over. We talked about the state buying it because it's right in the middle of the wildlife corridor, and it was all shut down. I'm not opposed to doing that, but that's what took place. And that's where we are here today. I just wanted to set the record straight that at that time, there was a lot of discussion about it. There was no doubt about it. And I've heard from many people back then. And I'm going to give the Yarboroughs a lot of credit, because even back then, as well as today, they did never approach me. A couple of their representatives have, but the family never approached me about it. And they've always told me that whatever decision we would make, that they would respect our decisions, and I want to compliment for them. So thank you.
Thank you.
That's my 2 cents.
I appreciate that. We have a motion and a second, and the question has been called. All those in favor say aye.
Aye.
Any opposed? Motion passes unanimously. Yes, I was just going to do that. You're reading my mind. There are a lot of us in this room, and there are only 2 potties out in the lobby. So we're going to take a 10-minute break. Please use this time to rearrange whatever, use the restroom if you can, and then we will come back to item number 32. We are going to start in exactly 3:20 according to that clock. So please be back in your seats, ready to proceed.
Yes, I do have Leon Flowers for the next one.
You're back in time.
If I was a kindergarten teacher, I would start calling out names from the back of the room.
This is going to be in court forever.
Did talk to the Boy Scout. I did talk to the Boy Scout.
Starting with Commissioner Delary, would you please come back to your chair?
No, I get it. You know,
No, I appreciate it. No.
Ladies and gentlemen, again, I'll ask you to please kindly take your seats and bring your conversations to a close so that we can resume our meeting. If there are any conversations that need to continue, they should happen out in the foyer, please. Just wanted to share before we get back into item 32. The board does appreciate that this is a very, this is a quasi-judicial, serious endeavor that we are about this afternoon. But this is also a very emotional topic for everybody in this room, and we recognize that. And so we're going to be very understanding and gracious about the fact that everyone in this room has an opinion and a long-held idea of what this property should and maybe shouldn't be. But we, as a board, have been given the responsibility to make sure that this quasi-judicial process is run the way that it's supposed to be run. And so I appreciate your patience. I appreciate your grace as we move forward with this next appeal for our staff, for board members, for every one of you in this room. We're all going to try and get through this next period of time as kindly with one another as we possibly can. So that was just my little 2 cents. That was the school board member speaking. All right, Ms. Moskowitz, item 32.
Okay, for the record, Mary Moskowitz, Planning and Development Services. Item 32 is an appeal of the planning and zoning approval of the preliminary subdivision plan for the Yarborough subdivision. Once again, the maps shown in the PowerPoint presentation are the same maps as the ones provided in your agenda package. I will try to include the page number for each map that is shown on the screen. For the record, on December 7th, 2022, the Planning and Zoning Commission approved the preliminary subdivision plan for the Yarborough Ranch subdivision containing 300 residential lots on 1,313 acres located on the east side of Snow Hill Road, approximately a quarter-mile south of Old Mims Road. Per Section 3513E4 of the Seminole County Land Development Code states that the decision of the Planning and Zoning Commission to approve a preliminary subdivision plan may be appealed to the Board of County Commissioners. Staff has received 2 separate appeals. This presentation is for the appeal for the Geneva Citizens Association. Per LDC Section 1.12, appeals to the Board of County Commissioners shall be de novo. The appeal from the Geneva Citizens Association claims that the PSP violates the requirements of the Seminole County Comprehensive Plan and Land Development Code. In their written appeal, the appellant made 4 separate claims. The first claim states that the GCA and other citizens attending the December 7th P&Z meeting were not provided due process because they were prohibited from discussing the development order approved by the BCC in 2008. As stated in the agenda memo, on December 7th at the P&Z meeting, the chair provided guidance to the attending public and noted that it is the policy of Seminole County to limit public comments to those pertinent information about the item being presented. In accordance with LDC Section 35.13, the PSP was reviewed by the Planning and Zoning Commission for compliance with the LDC Sections 35.43. This section lays out the submittal requirements for the preliminary subdivision plans and can be found in your agenda packets. Per LDC Section 112C, decisions from the BCC are subject to the terms of Florida Statute 163-3215. This statute states that the appeal must be filed by a petition of writ of certiorari filed in the circuit court no later than 30 days following the rendition of a development order of a local development decision. The 2008 DO 070550040, the period has passed and no appeal was ever filed. Claim 2 by the appellant states that the PSP violates Part 57 because it amounts to a transfer of density without satisfying the requirements to do so. In their written appeal, the appellants provide no information on how this requirement has not been met. The entirety of Part 57, Econolatchee River Protection Overlay Standard Classifications, is included in your agenda packet. Section 30-1083 describes the area that the Econolatchee River Protection Overlay Standards are applicable. The overlay district contains 2 sub-areas: the Econolatchee River Corridor Protection Zone and those areas containing rare upland habitats. Staff finds that the Yarborough PSP is located in the Econolatchee River Basin, but outside of the Econolatchee River Corridor Protection Zone. Part 57 provides 3 scenarios in which density credits apply. The first one, per section 30-1085-6, density credits apply for upland buffers shall be encouraged and may be awarded. Second criteria, in section 30.1085-9, preserved rare upland habitats shall be eligible for the award of density credits. And then finally, sections 30.1088G, 1 and 2, provide that the density credits for properties located within the Econolatchee River Protection Zone. Per section 30.1087, the Seminole County Natural Resource Officer shall determine if a property is in any extent in the Econolatchee River Protection Zone. Based on a review of the Seminole Land Development Regulations, the St. Johns River Water Management District Guidelines, and a site visit conducted on November 3rd, 2022, the Natural Resource Officer has determined that the subject property is not located within the Econolatchee River Protection Zone. For the cluster provisions and density bonuses associated with the Yarborough PSP, the property owner elected to utilize LDC Section 30.109 to develop the cluster subdivision and provide for the perpetual open space easement, and did not utilize LDC Section 30.1088, which is an optional provision. So you had choices. They chose 3109, not 30.1088. Based on these findings, staff has determined that the LDC Section 30.1088, including but not limited to sections 30.1088D and E, are not applicable to the Yarborough Ranch PSP. For Claim 3, the appellant states in the written appeal that the PSP violates the Seminole County Comprehensive Plan because the requirements of specific issues or policies have not been met and in some cases ignored. However, the appellant provided no additional written information on how the requirements have not been met. As provided in your staff report, staff provided an analysis of each reference issue or policy. A copy of each reference issue or policy is provided in your agenda package. Based on the analysis, staff finds the PSP is in compliance with the Seminole County Comprehensive Plan requirements. The fourth claim, the appellant states the PSP violates the Seminole County Land Development Code because the requirements of specific regulations have not been met and in some cases ignored. Again, the appellant provided no written information on how the requirements have not been met. As provided in your staff report, staff provided an analysis of each referenced area code section. This is provided in your agenda packets. For Land Development Code Part 54, Aquifer Recharge Overlay Zoning Classification. The map shown here on the screen shows the most effective recharge area. So the straight lines are the, parallel lines are a regular area. It's that kind of honeycomb shape. That is the most effective recharge area. And that area outlined in red, that is the area of Tract 3, the subject property for the Yarborough Ranch PSP. So what we show is there's a small area in the northwest portion of the Yarborough Ranch PSP that is within the Aquifer Recharge Overlay. This area is located in a conservation tract, and there is no proposed development within the Aquifer Recharge area. Therefore, staff finds that the development standards in the LDC Part 54 Aquifer Recharge Overlay Zoning Classification are not applicable since no development is being proposed within the Aquifer Recharge area. Based on the analysis, staff finds the PSP meets the requirements of the Seminole County Land Development Code related to preliminary subdivision plans, including Chapter 35, Sections 30.109, 30.111, and Chapters 30, Parts 57 and 54. In conclusion, the Yarborough Ranch PSP meets the applicable development requirements of the Seminole County Land Development Code and the Seminole County Comprehensive Plan. Therefore, the decision to approve the Yarborough PSP should be upheld. Staff recommends the Board of County Commissioners uphold the decision by the Planning and Zoning Commission to approve the preliminary subdivision plan for the Yarborough Ranch subdivision. This concludes my report.
Thank you, Mary. The applicant will have 15 minutes to make their presentation. And
where you have the subdivision.
This one of the black and white.
That one's perfect. Thank you.
Shani, are you counting how many? Okay, thank you.
Thank you, Madam Chair and Commissioners. Again, for the record, in this second appeal, my name is Rebecca Wilson, 215 North Eola Drive, here on behalf of the property owner. And I just want to place into the record that the Yarborough PSP, along with its supporting data, was given to the county in July of 2022. That data, along with the staff report, is the competent substantial evidence showing that this application is in compliance with both the county's comprehensive plan and with the Land Development Code. Just something that I want to point out, and I'm going to keep most of my time for rebuttal because I agree with your staff. The appellant just sort of threw spaghetti at the wall to see what would stick, and I'd like to see what evidence they're going to present. But this is the actual subdivision plan, and I just want to point out a couple of things. It's turned sideways, so to your left is north and to your right is south, and that's Snow Hill Road. You see an out parcel there. Just Mrs. Yarborough reminded me the school board actually owns that site. If you want to talk about schools, that's not what we're here to talk about. Also, you can see where the econ is. See how it's way south of this piece of property? So again, you can see portions along the econ on the north side that are not developed. And they're not developed because they were part of this original plat in 2008, and that is area that was preserved. And all of the property that we are discussing today is outside of the 1,100-foot Econolockahatchee corridor protection zone. So I just wanted to point that out on a map. And with that, unless you all have any questions for me, I would just like to keep the rest of my time for any responses. Thank you.
You have 13 minutes remaining according to my trusty Samsung.
All right, thanks.
Commissioners, any questions at this point?
Yeah.
Commissioner Herr.
Mary's getting her steps in today. And by the way, doing a heck of a job.
And they're both Marys.
Our Mary.
I figured.
So if I overlay your honeycomb map with this map, which are facing in different directions.
I know.
You end up with this side. Yeah, thank you. And so that's all left without, nothing is being built on that. But what are these properties on the other side of this property line that we're talking?
Subdivision.
That's a different subdivision, yeah, that's not related to the...
And so what's allowed, that is in the honeycomb area, and what's allowed to be put there?
So there are certain regulations, so that is in the high recharge overlay district, and so that restricts the amount of impervious surface you can have there. So if there was development in the honeycomb-shaped area, in Chapter 57, there are specific requirements that must be met about the types of impervious surfaces that can be allowed. But since there is no development in the high recharge area, we didn't even look at that section of the code.
Okay, thank you, I appreciate that.
No problem.
Great question. Any other questions? Nope. Okay. If the appellant would like to make their way forward, and if you would state your name and address.
Yes, ma'am.
Thank you. You'll have 15 minutes.
Good afternoon, Commissioners. My name is Jacob Schumer, 352 Coble Drive in Wekiva. I'm representing the Geneva Citizens Association. There were two items on the appeal, of which I'm going to talk about the first two because they're the legal aspects that need an attorney. And just to go back to what we were talking about earlier regarding quasi-judicial, yes, the question is whether or not you have competent substantial evidence to support whatever decision you make here in light of the law. That doesn't mean that you don't need an engineer to say the sun comes up in the morning. You can take basic facts without taking them from an engineer. But there's another flip side to quasi-judicial, and that's that affected parties have the right to notice, they have a right to due process, and that means notice and the opportunity to be heard. And that's the point of the first issue regarding not being allowed to speak on the development order from 2008. And I understand we're here and you've allowed us to discuss this order. So thank you for that. And it's necessary because, as you've heard from Mr. Chipbuck and from the staff, that development order, it's not impertinent. It is absolutely pertinent. And in fact, it is one of the three legs this PSP is standing on. So we have a due process right to speak on that development order, including its legality and what it actually says. And that's especially important here because I'm still not sure exactly what the staff is saying that development order means to you today. You have a preliminary site plan here today, which is a quasi-judicial item. Does that order relieve your obligation for the other criteria? Does it relieve your obligation somehow? Does it tie your hands? It can't do that because you have a quasi-judicial decision here, and I'm supposing what it's supposed to do is it's supposed to transfer density because the real problem with this application is that the owner of Tract 1 and Tract 2 did not sign on to this application where you're using their density to approve a plan on Tract 3. So moving on to the development order, which is why I don't think that it should be used as a basis for the PSP, why I don't think that's legally allowable. Even if you look at the face of the development order, if you do not have to worry about all the issues regarding whether or not it was enacted properly, which I will get into that. You can look at the face of the development order, and it tells you that that issue of whether or not there's a cluster subdivision on that property is not yet decided, and you should not grant that cluster subdivision unless you get the sign-on from the owner from which the density is being taken. I do have documents here. I don't know how to activate the overlay.
I got it. Why don't you give me a hand there?
Thank you. I'll stay here and, yeah, have a good time. So I'm going to show the development order, and it's highlighted, so it's not too hard. It's pretty easy. But here's some important parts. First of all, it says that track 3 is
Madam
going
Chair,
to
point
have
of
to
order.
be...
Can we zoom into that, please?
Yeah, if you don't mind, Caesar, making that just a little bit larger. A little bit larger. No, we're going the wrong way.
Maybe
Yeah, there we go. Thank you.
Move it over.
Okay.
Is that better?
Yes, thank you.
Much better, thank you.
Thank you,
Madam
Commissioner
Chair.
Delory.
So Part C of this development order says, at the time of development, track 3 must replat in accordance with the requirements of the code. And that's especially important for why nobody was mad in the first place. They were told that it was going to come back. And when you look at section 30.109, which is the only section that's cited in the development order for how it is authorized, let's see, says that orders regarding clustering occur during the platting phase, and the application for the plat in which there is a clustering has to include specific development, a specific development plan for the entire site, which includes both the specific location of lots on site and that identifies all remaining open space platted as a lot that is to be included in the open space easement. And so here is the plat that is supposed to be specific and laying out all the lots in that tract. And I don't see any lots. This was not treated as a final decision to cluster in the subdivision because there's no decision regarding the lots. I think we can all agree that that is not a specific development plan that has lots, that shows individual lots to be developed. And so I think that a fair reading of this is that this wasn't meant to be a final decision as to tract 3. But also, it says that the open space easement is going to be granted as to tracts 1 and 2. And yes, you got that open space easement as to tracts 1 and 2. But you look back at the code, the easement, which is to be preserving the remaining open space, needs to be recorded as for the entire property, and it needs to include the residential lots and the remaining open space. And this only applied to tracts 1 and 2, not tract 3. The easement was not granted as to tract 3, did not include the residential space. So I think we can all agree that that was not in compliance with 30.109. But maybe, that's, and the fact is that the order itself seems to indicate that it's non-final because of the requirement to replat. But maybe you think that, it doesn't matter because it was 15 years ago. The decision was made back in 2008, and the time for appeal was passed. Building on what was said earlier, the thing is that decisions that are made without providing the proper hearing are not subject to that 30-day limitation. And as I mentioned earlier, quasi-judicial hearings, there is a right of affected parties to speak, to be heard on matters that affect them. And when you are applying land development criteria to a decision as a quasi-judicial board, they have that right. And as stated by staff, that hearing never took place. It was treated as a consent item. There was no evidence presented at all. And I have case law to that effect that I'll hand to the clerk. There's 8 copies. And that all goes back to why does this order exist? Why does it matter to you today? And the answer is that tracts 2 and 3, or tracts 1 and 2, the owner is not here. But they're using that owner's property rights to justify why tract C is allowable, why the 300 units on tract C is allowable. And that goes into the distinction between assigning density and transferring density. I'm sure you've seen it all the time. If a property owner comes to you with one giant chunk of land, you can treat it as a single chunk, and sometimes you can assign that density to one smaller chunk of land. But it's a different situation where the owners are different people, where there is no common ownership. That's where you would get a transfer. That's not an assignment, that's a transfer, because it's an entirely different party. And that's the situation that you have before us on this quasi-judicial PSP. There's a St. John's is not going to be bound by this decision that you make on the PSP or anything going forward unless they sign on. But you're using their density. And so you may say that that was already decided by the DO, but as we've talked about, there are issues with the DO both in its substance and in the process by which it was approved. And so, and then Ms. Wilson said, if it goes away, they can build a lot more. I'm not sure the county would want to rely on a DO with that kind of footing to protect your wilderness. You don't want to rely on that for a promise that it's, this is going to be limited to this amount of units. And the county wisely has a whole other, okay. I got it. No. Sorry. That's okay. I was trying to be helpful. 30.1088 is the provision that the staff mentioned as an optional provision, and it's certainly optional to transfer credits. But importantly, it repeatedly says, in all situations where transfer of density is authorized pursuant to the terms of this part, and this part meaning the overlay protection area. It says that every time. It includes things like getting a transfer deed. It includes protections for where you can transfer density, because you can't transfer it across bodies of water. You need a formal transfer so that you know with confidence that the owner knows what they're doing. If any of you are lawyers, you know the rule of statutory interpretation. When to authorize something one way is to prohibit it any other way. Your code, Part 57, authorizes how you transfer density from one property to another, from one property owner to another, and it didn't do that in this case. They chose this 30.109 procedure where it was transferred before the property was sold, except not in compliance with 3109, or 3109, but not in compliance with this. But again, you don't have to rely on that. Because the order itself says that Tract 3 is going to come back for replat. And so what's going to happen then? Because that's when you're supposed to apply 30.109. That's when you're supposed to decide whether or not it's a proper cluster subdivision under the many, many criteria that is applicable to cluster subdivisions. So are you going to consider your hands bound then? Are you going to consider the criteria satisfied then? That's a question that the text of the development order says you don't have to think about, because actually that question is not decided yet. You get to decide then what you believe is an appropriate cluster subdivision. That is it for me. I'm going to turn it over to the Mr. Creedon with the Geneva Citizens Association.
Actually, you have 2 minutes left for your presentation. So if Mr. Creedon would like to hustle on down here and speak for 2 minutes.
I would like to get 6 minutes on the public speaking section, please.
I'd like you to come down and say that into the microphone so that I can re-explain how it is that we're operating today. So the appellant had 15 minutes to make a presentation, and we have not moved into public comment yet. So if you are, would you come on down so I can make sure you're really because sometimes when you walk, it's hard to chew gum and listen at the same time.
So I'm not going
So-
to introduce myself
No,
yet,
you're
'cause I'm
not. So,
speaking
because you're
yet.
going to listen for just a moment.
I'm waiving these
Mr.
two-
Creedon, would you please listen for just a moment?
Yes, ma'am.
Yeah, so what the rules were that we established at the beginning is that there is going to be 15 minutes for the applicant and 15 minutes for the appellant. Your attorney just took your 15 minutes. So if you would like to speak under public comment, which we have not gotten to yet, then that will be your opportunity. If you speak for 6 minutes on behalf of the Geneva Citizens Association, no one else here who has filled out a form to speak as a part of the Geneva Citizens Association will be allowed to speak. You will be speaking on their behalf.
Yes, ma'am.
I don't know that they agree with that. If I may, if you choose to speak for 3 minutes as yourself, you are welcome to do that. But we'll get to that when we get to public comment.
Right, I'm going to wait for the public comment and get my 6 minutes.
Chairman, I'm going to object to that.
You may sit down, Mr. Creedon. We are not at public comment yet.
Chairman, I'm going to object to that. Mr. Creedon filed the appeal on behalf of Geneva Citizens Association, Inc. He was sent.
Madam Chairman, point of order. Can you just
Yeah,
come to
we
the
need to
podium
have you
and
come to
speak?
the microphone. Mr.
Sorry,
Creedon,
Chairman.
yeah,
I
Mr. Creedon,
object
if you
to
would
that.
please have a seat.
Mr. Creedon filed the appeal on behalf of the Geneva Citizens Association, Inc. He gave his personal information and he signed it. Weeks ago, each one of us who are party to this were given the very specific rules that we have had to live by. The property owner has had to live by. Not only that, the property owner has also had to be ready to defend both of these. So we're going to ask that they are held to the exact same rules that they were given. He has 2 more minutes that he can speak under, and no one who represents the Geneva Citizens Association, Inc. gets 6 minutes. They got 15.
Yes, ma'am.
Thank you.
This is still our meeting, and I appreciate your input. But, so, Mr. Creedon, I'm going to reiterate what we're going to do next. You have either 2 minutes to complete the rest, delete.
Your 15 is up.
Your 15 is now up, yeah. I'm going to pause it back. She's joking.
I was joking, relax.
She's joking.
That's what the bell was.
Yeah, so at the time that your attorney, who is representing your organization, stopped speaking, you had 2 minutes left as a part of that 15-minute presentation. If you would like to speak for 2 minutes left in that presentation, you are welcome to do so. When public comment comes, if you would like to speak as an individual citizen for 3 minutes, I am going to allow you to do that. That now is not that time, so I've asked you to take a seat.
Okay. But wait a
Unless you're saying, you said you weren't taking your 2 minutes.
You offered me 2 minutes.
Have you changed your mind?
Right.
You've changed your mind.
Take the last 2 minutes and then speak 3 minutes as a private
I'll
citizen.
continue it in the public section for
That's
like 3
fabulous.
minutes.
Okay, have a seat then, please.
Okay? Are you ready?
No, sir, we are not ready. Would you please have a seat? No, he said he does not want the 2 minutes.
I want the 2 minutes.
He does.
And I will complete the statement later on.
He's going to complete the 3 later. He wants the 2 minutes.
Your 2 minutes are
I'm
starting
going
now.
to truncate my statement.
Your 2 minutes are
2 minutes
starting
now,
now.
3 minutes after.
Your 2 minutes are starting now.
Okay?
Your 2 minutes are starting now.
Okay, very good. Okay, my name is Richard Creedon. I'm sure you all know me. I live at 1172 Apache Drive, Geneva, Florida, and am the Vice President of the Geneva Citizens Association, Incorporated. Way back in 2008, when the Yarborough Development Order was written, we were all very glad that the largest part of the ranch would be permanently preserved from development. Heck, I even wrote a letter of support that I fully stand behind. We all naively assumed that the county had done everything correctly. Now fast forward to 2022. Pulte Homes was not satisfied with 1-acre lots, so tried for half-acre lots, which awakened the Geneva community. Next, Pulte tried for a water plant, which is clearly prohibited by the comprehensive plan for any new developments in the rural area. This really upset our community and caused us to thoroughly research the background of the happenings in 2008. We truly believe that all of the players for the county intended to do the right thing at that time. Unfortunately, The process had to be severely rushed in order for the Yarboroughs to close the sale of Tracks 1 and 2 to St. Johns River Water Management District. Haste makes waste, and some serious errors and omissions were discovered. I venture that if Pulte had not first asked for the half-acre lots and then the water plant, Geneva's sleeping dogs would never have been awakened, and the proposed 300 homes would have been constructed without any serious opposition. I will say the rest of my comments later.
Ms. Beach, how many people do we have right now that would like to speak?
17.
Okay.
Madam Chair,
Yes, Ms.
before we move, I
Yeah,
have
we're
a
not-
question for the attorney.
Yes, absolutely. I just wanted to get a feel for what type of time we had. Mr. Zembauer.
Thank you, Madam Chair. You gave us two pieces of case law
Yes.
that were circulated.
Yes.
And there's yellow highlighted areas in both of these.
Yes.
Were they highlighted by you or somebody on your behalf?
I did that.
And is that what you're asking us to pay the most attention to?
Yes, I would say those are the most pertinent. Well, there were some additional parts that I wish that I had highlighted when I was sitting down there.
Sure.
But, yes, those are the most pertinent parts. I would say.
So, question, if you would entertain me on this question. The Webb versus Town Council of Hilliard, you've outlined as regards to a notice of a zoning change.
Right.
Do you perceive this has been a zoning change?
It's not a zoning amendment, but the same rules apply to both zoning changes and any change that applies the comprehensive plan and land development regulations that are enacted in pursuant to the comprehensive plan.
Okay, and that, understood.
And I didn't legal brief it. I could have dropped 15 cases on you, but I didn't want to bury you.
Trust me, I'm used to seeing reams of legal opinions. In Bula versus St. Augustine Beach.
Yes.
You've got a complaint of notice of an affected party where an ordinance was voided. Is that what your intent was, for us to pay attention to that portion the most?
The important part, and that's the case where I wish I had highlighted a little higher up, because it says that when a ordinance is enacted without the proper notice and hearing, it is void, it is not voidable. It is, and therefore, and this is an analogy.
Sure.
And therefore, this man was not required to appeal, the man in the case, was not required to appeal within 30 days because he was newly injured the moment somebody tried to apply that void rule.
Sure, and in that same vein, a follow-up, and I'll wrap this up, Madam Chair. This would be a failure to notice appropriately that you've outlined.
It was also a lack of hearing.
Okay.
In that case.
And yet, your client just came up and testified that he wrote a letter and supported, on behalf of the association, prior to that hearing, and as part of that hearing.
Right.
Do you find any conflict with that?
Well, the DO was not given notice. Well, there are a few things. One is, it doesn't matter whether he personally knew about what was going on, except that they didn't know everything about the DO, because that was changed at the meeting. But also, the hearing itself never took place.
Okay.
I think that many people, as he was saying, many people understood you're getting a giant piece of property protected by a conservation easement. Didn't realize that it was lumping 300 units into another part of the property abutting it.
Okay, understood. Thank you very much. Thank you. Thank you, Madam Chair.
Sure. Any other questions from the board?
I do.
Ms.
I
Hart.
have one. Sir?
I'm sorry.
So this is in regard to the development order, item C, that you put up there, and I think you highlighted.
Yes.
And I think the argument you made was that the replat needed to happen, but the first part of that sentence says, "at time of development," comma. So did you expect it to have happened back in '08, or at time of development, which we're not at yet?
No, it would be, this is part of that process, I would say. This is the time of development. So they will have to bring forward a plat eventually, a replat of Tract 3. I'm not saying they violated that.
Oh, I misunderstood that. I
No.
thought you were calling that out as a violation.
No, no. What I was saying is that that means that the decision of whether or not an optional cluster subdivision will take place on track 3 has not yet occurred, because that's when the section under 3109 says that's when you're supposed to decide whether or not there's a cluster subdivision. And that makes sense because the plat that was approved here doesn't have any lots on it. It's one giant tract. And so that, if you're trying to say how many units are going to be in there, you have no idea at that stage. So my interpretation of that was they were trying to say, this is what we intend. We're gonna say max 300 units, and we're gonna figure out whether or not the plat works out later. That would be my interpretation of that. But yeah, I wasn't trying to say that they violated anything pursuant to that provision.
So it comes down to which section, based on your interpretation or our interpretation, is applicable?
Which section of?
3109, 31008.
Right, and yes, though I think that 31, the question of whether or not they transferred, I think they both have to be applicable, is the thing. Like, they both apply. They obviously are both in law. And the question is whether or not that you can transfer density from one person to another via 3109. That's certainly one question. It doesn't say that. It says that you can assign it to, it appears to be about a single owner. That would be, I think, one of the major questions.
Thank you.
Any other questions or clarification? Mr. Chipak, when we get to a place where you can give us your take on all of that, we'd appreciate it. I know this was just handed to you on the dais as it was us, so I don't expect you to have it right off the top of your head, unless you...
Whenever you're ready.
Well, if you're ready, I'm ready.
Okay.
Okay, I would love to hear your take.
I think we need to go back to the Creekside Acres plat, specifically. I have a copy of the plat here. There's copies in your book, and I'm going to put something on the overhead if you will indulge me.
I think staff's doing it now.
I think Mr. Chipak would like to go down there so he can point to it on the short throw. Yeah.
Absolutely.
Yeah, as you can see, this is the plat that was approved in 2008, Plat Book 74, page 1. I've blown up the dedication language because I have to at my age to be able to see it.
Paul, can you speak into the microphone, please?
Yes, sir. Specifically, in looking at the plat language, the Yarboroughs, as the property owners, have caught in it. Okay, tracks 1 and 2 are hereby dedicated to Seminole County in perpetuity as an open space easement. This easement shall serve the same purpose and permit the same use on the open space easement between the owner and St. Johns River Water Management, duly recorded at 6928, page 1027. No development shall be permitted within the area of said easement created by this plat, except as permitted in paragraph 2A of the open space easement, and except that upon 4 acres, 1 acre residential lots may be created by replatting the portion of tracks 1 and 2, provided the minimum developable uplands open space required by the development order recorded at 6928, page 101, I believe that's 8, for the development of track 3 pursuant to the clustering provisions of the Land Development Code of 30-109 or its successor provisions remains outside the area of the replat. In addition, at the time Tract 3 is replatted, a minimum of 40 acres of Tract 3 shall be dedicated to Seminole County as an open space easement in accordance with the clustering provisions of the Land Development Code 30.109 or its successor provisions, and the same uses and restrictions as applicable to Tracts 1 and 2. So with that, I would submit that the Board of County Commissioners in 2008 knew what they were doing, intended that the plat was, the development order, and the open space easements were all part of the same transaction, and intended that the property of Tract 3 would come back for a final plat, so the units that were assigned to Tract 3 could then be placed on the ground in accordance with Section 30-109.
Stay there for just a minute, Paul, in case there are some questions. You'll be right there. Commissioner Zembauer.
Thank you. Mr. Shipock, in layman's terms, I want to make sure I've got this right. In layman's terms, does this mean that the owners of the other tracts were involved in the transfer of those rights?
According to the land transactions, at the time of the February 12th hearing, the property was all owned by the Yarboroughs, Tracts 1, 2, and 3.
Understood. We heard some testimony earlier, or some aspersions that somehow St. John's Water Management and non-owners didn't have the ability to transfer those rights, and somehow that's what happened. And I'm just trying to verify what you're saying here is the owners of those other tracts, the Yarboroughs, were involved in that transaction of transfer of rights. Is that true?
I believe, not to speak for the appellant, but I believe their argument is the Water Management District should be part of this application.
Understood.
Okay. I believe what I just read is that the intent at that time was that the units from Tracts 1 and 2 through the open space easement were specifically transferred to Tract 3 at that time, and through that plat, development order, and open space easement. And accordingly, Tracts 1 and 2 were then subsequently sold to the Water Management District with the understanding that they were buying those tracts subject to those open space easements and less those development rights which had previously been severed pursuant to the plat.
Understood. Thank you.
So those 300 units were already assigned to Tract 3. They just have not been specifically placed on the ground yet.
Understood. Thank you.
All right. Any other questions for any other staff members or applicant or the appellant from the board before we move into public comment? Okay. All right. Ms. Beach?
We have Dr. Peter Burrill, followed by Scott Lawton, followed by Maria McKenna.
Okay. And I will just remind everyone that we are trying very hard to hear new information with each public commenter. So if you're repeating what has already been said, that would be unnecessary for the board to hear, and I may ask you to stop talking. Mr. Burrell.
Thank you, Commissioners. It's Dr. Burrell. Thank you. Palm Bay, Florida, Brevard County. I respectfully request that you support the appeal for the PSP for the Yarborough Ranch Tract. Per my full report, the wastewater infrastructure planning proposed for this property is not consistent with the policy of the state of Florida through the DEP, a state agency that is responsible for water quality for the citizens of the state and Seminole County. Commissioners, Governor DeSantis on the 10th of January here in 2023 produced an executive order 23-06 that's restated his priority policy agenda to solve Florida's water quality problems, specifically to reduce nutrient pollution from septic tanks that continue to impair Florida's sensitive and protected water bodies, such as the Econ and St. Johns River, which are both protected by the DEP's Basin Management Action Plans that the county is responsible for. These are both adjacent and hydrologically connected to the Yarborough Ranch tract. Further, state statute protects the underlying Geneva freshwater lands from the proposed development, which would impact and degrade this essential and protected groundwater public resource that, again, is essential to the health and welfare of the current residents of Seminole County. I'm sharing this with you today as an expert environmental scientist, and I want to thank you again, Commissioners, for keeping in mind the health, well-being, and future of the residents of Seminole County. Thank you.
Thank you very much. Is our next speaker?
Scott Lawlin, followed by Maria McKenna, followed by Melissa Boyer.
Good afternoon, Commissioners. Mr. Constantine, I'd like to acknowledge that I admire your common sense approach. I wish there were more of that. If you could
Sir,
pass some of that around.
I'm sorry, did you say your name and address for the record?
Scott Laughlin, 1012 B Lane, Geneva.
Okay, your time will start now.
I'm just speaking as a concerned citizen. Been in the Geneva area for about 12 years. My wife's been here for about 25. I'm a Florida native, grew up in a rural community just north of here, Samsula. It's barely recognizable anymore because of development. I think we all know that urban sprawl is taking its toll on the environment. Habitat fragmentation, loss of biodiversity. Max Perlman, who was the VP of Land Acquisition for Pulte Homes, stated that the project has been designed to preserve the area's natural resources. That seems like a paradox to me. When you're developing, it's hard to preserve the natural resources. I just want everybody to consider the outcome of this, the infrastructure toll, water quality, water quantity, the adverse effect on the environment. Thank you for your time.
Thank you. Ms. McKenna? Just a reminder to state your name and address for the record, and then your time will begin.
Yes. My name is Maria McKenna. I live at 450 Butterfly Forest Road in Geneva. I'm right across from Yarborough property, and our well water comes from the Geneva lens. I believe that the planning and zoning ruling in approving the PSP set a precedent that violates the 2008 comprehensive plan by allowing a higher density than one home per 5 acres. And more importantly, it will be used again and again by future developers. If we start drawing salt water from our well, we can no longer live comfortably in our home, like in California, where they can drive trucks to go get water that they cannot drink locally. Nor could we sell our home for its current market value. And down would go the taxable property values of many Geneva homes. This doesn't seem farsighted to me. But for me, this is more than just about a local Geneva issue. The way our lawmakers conserve the most vital natural resource, our water, is crucial. It is my fervent hope that this meeting will not be a cautionary tale to other Florida counties, but I hope this meeting will reflect a visionary spirit to be emulated by future decision makers. Thank you.
Thank you, Ms. McKenna.
Melissa Boyer, followed by Stanley Stone, followed by Eva McDonald.
So if Mr. Stone and Ms. McDonald would make their way down now, that would be fabulous.
Good afternoon. My name is Melissa Boyer, 295 Butterfly Forest Road. Not only am I an affected resident, I am a directly affected resident like the previous speaker. I'm basing my statement on competent evidence. Comprehensive Plan Policy 11.14 established the need to protect the Geneva lens, which is also my water source. And I think every citizen counts. It's meant to protect the wetlands and the flood-prone areas. The forest behind my property is the floodplain. The floodwaters come on my property. Can you imagine what's going to happen if they build 300 homes above?
where our current properties lie, where that water's going to go? The Yarborough Ranch PSP violates policies. There will be an impact to the Geneva freshwater lens due to the increase in density that is not allowable when following the current land use code. This parcel, tract 3, parcel 3, is not zoned for 300 lots. It is zoned for no more than 160, and transferring 140 lots from another location to this property is not protecting the Geneva lens, the wetlands, or sensitive upland systems. The increase in density will increase the demand on Geneva lens. There will be an impact to the wetlands. Some of those are on my property, and sensitive upland systems. Looking at the lot layout in relation to the sensitive upland systems, one can see that loss of water flow due to development. One can say, look at the land that has been put into conservation as consideration, but that hardly makes a good argument when other sensitive area is being affected in a negative way. Saying, hey, we're saving this land, but we're going to trash this land, does not make sense to those of us that live there. I doubt this was not a consideration when the parties came together in 2008. I doubt there was any consideration given to the rural nature of the area and the surrounding properties. The goal in 2008 was to accomplish the sale of the property. The St. Johns River Water Management District wanted all of the acreage but couldn't afford it, so they settled. The Yarboroughs also settled. They agreed to sell their property at the current property value and take a charitable tax contributions afforded landowners when they sell their land for conservation. All was good in 2008. In 2022 and today, the impact of this decision is being brought to bear, and we realize the unintended consequences of 2008. We started realizing that when they wanted to put a water plant in. Approval of the Yarborough Ranch PSP fails this policy and fails the community. I ask you to uphold the Geneva Citizens Association and reverse.
Stanley Stone, followed by Eva McDonald, followed by Virginia Creedon.
I'm already jumping ahead. Go ahead.
Thank you.
Name and address.
Sure. My name is Dr. Stanley Stone. I live at 600 Snow Hill Road since 1980, Geneva, Florida 32732. I'm here to speak and ask you to consider other things besides the density that we've been talking about. My initial, Madam Chair, was to talk about the density in Section 30.109 and all that stuff, but I hear you. I'm going to go on to something else. The comprehensive master plan to study its environment impact, whether the existing infrastructure, the road, the traffic, or water could support this subdivision. My question is, has a compatibility study been done? And if so, is there sufficient documentation in the plan to support the density? My also point I want to make is, I think I stand here a little different than everyone else. I've been, as I said, on Snow Hill Road since 1980. My wife and I, Barbara raised Terrence and Shannon. But my wife's family, the Banks family, which most of you know, was there 91 years on Snow Hill Road. And I think that's a lot to be said that I don't hear anybody able to say that. And so we also have the black community, and it was a dirt road on Snow Hill Road back in the day. So I want to put that out there because I think it's significant. Also the traffic. No one's really talked about the traffic. If you look at the traffic that goes by my house every single day, minute after minute, hour after hour, you now have dump trucks trying to make it to the dump site to come back. I also have observed in my time with the dump trucks, the increase in traffic of a fatality. I've observed school bus accidents. I've observed a lot of things that happen, and we really have to think about that. The approval of this project will, in fact, I would say exponentially make sure that it goes 3 times what the traffic is right now. And if you know, that's something. The other thing I want to mention is about the flooding. We recently had 2 major storms. The 2 major storms that we had caused the flooding on Snow Hill Road. My wife tells me that it used to be where the 2 ponds on each side would meet. Well, I saw it this time because down by the bridge, they had to close the bridge for 3 or 4 days because of flooding. Can you imagine what's going to happen and the impact that it's going to have on Snow Hill Road, 419, 426, and 46 if, in fact, we allow 3 times as many cars that will have to be rerouted because of the flooding? And I think that's a significant negative impact. We've been talking about the rural character of the area. I think that the people that live out in Geneva are out in Geneva. That's 3 minutes?
It goes by so fast.
Anyway.
Why don't you finish your sentence?
Okay, I'll finish. Finally, let me say that at the end of the day, does the county want to preserve this area as a unique country area or yield to the density developers who will profit and then leave? Thank you.
Madam Chair?
Yes.
Let Mr. Stone, just to let you know, as your district commissioner, I have weighed in with FDOT and the sheriff's office on the dirt dump trucks that are running up and down out there. It is not going to the dump. It's coming up out of Orange County and going up into the Sanford area, hauling dirt back and forth. So I've made those calls and asked those 2 agencies to do what they can. They obviously have the right to use the road as a public road, but to make sure they're doing it safely and appropriately.
And I
So
would
thank
say,
you.
and I say we thank you for that because I've too have spoken to Sheriff Lima and my brother-in-law has spoken to Sheriff Lima, and they are policing that road
Yes, they are.
constantly. And I agree, it has reduced the speed.
Yeah.
But can you imagine 3 times the amount of traffic that people are going to come use that road?
Understood.
Thank you, sir.
Thank you.
Thank you.
Yes, ma'am.
Thank you. You can have a seat.
Oh, okay.
You did beautifully. I think I was just going to say that because I have my clock ticking, if we could maybe hold our comments until the end, it's going to be too hard for me to
Sure.
try and add 2 minutes and take 2 minutes and
My apologies.
help a sister out. Thank you. And
I yield back a couple minutes.
Shani, could you call the next couple of folks for us, too?
Absolutely. We have Eva McDonald, followed by Virginia Creedon, followed by Isaac Abdumasiah.
Thank you.
Can you shrink that down so it takes a whole thing? I'm Eva McDonald, 255 Butterfly Forest Road in Geneva, Snow Hill. I'm here to answer a question. Will the Yarborough development set a precedent? To answer this, we need to look at a few things. One, who's who in this deal in 2008? We also need to see how many clusters exist there today and the whole truth. So one, who's who in this deal in 2008? Lou Tulp is negotiator, broker, liaison, and developer for Creekside Acres deal. Bob
Ma'am,
Delaria-
before you go any further, and I this won't take your time away, we'll go ahead and stop the time. I'm just going to caution you that earlier today, I was very specific that we would not be making personal attacks or anything that would be slanderous or disruptive.
Oh, no,
So
this isn't at all. This is all from the clerk's department and
if we're
everything.
calling out individual people and going to be making accusations of any kind, I will stop you.
Thank you, Madam Chair. I think that is appropriate and agree 100%.
Okay. Go to 3. Okay, so we're not going to really talk about the truth then. All right, so how many cluster subdivisions exist within a rural boundary today? How many of y'all know there's 3?
Ma'am, your comments need to be directed to this board, and
Okay, I got you. So how about 3? 1, Creekside Acres, It's large, very noticeable. If you don't realize, all 3 tracts are considered part of the subdivision. Very important. Then there's also a small and nondescript cluster subdivision by a developer hiding in plain sight. There are 2 lot cluster subdivisions, and you can look them up on the county records. Brooks, Brumley Bounty at the end of Brumley Road, and Tolp's Treasured Holdup at the end of Curryville Road. Pay attention now to the location on the board, those little red lines, okay? And notice where all the boundaries touch. So here's the truth. Oh, sorry. Go to 3. Quick look at Brooks Brumley Bounty. It's a subdivided 18 acres. The word cluster gets around the zoning and flew. It's hiding in plain sight. But why is it here? Very important. So here's the truth. Per my conversation with the development department, subdivisions can add land from parcels they touch, okay? They can add land from the parcels they touch. Look at what parcels touch both of the little subdivisions and look at where they touch in Creekside Acres. Over 4,000 acres of potential clustered subdivision is up for grabs. Got the next one. So, will the Yarborough Development Order set a precedent? The board and friends are literally banking on it. I'm done.
Yes, thank you so much. Mr. Abdul-Masai, and who is after?
Actually, Virginia Creedon is before Isaac.
Oh, okay. Ms. Creedon, you are next, and Mr. Abdul-Masai, I'm sorry.
Oh, I'm not next?
No.
Okay, no, that's fine.
Ms. Creedon is next, and then you.
Is it possible for me to give my 3 minutes to my husband to add to his speech?
No, ma'am.
Okay, thank you. Virginia Creedon, 1172 Apache Drive, Geneva, Florida. I go back to the first law, Genesis, when we were told how the earth was to be greeted with great stewardship. A former pastor in Seminole County spoke of that stewardship. He spoke of the need to preserve for future generations, not to worry about maximizing profits, but to save for future generations, the way the people in Snow Hill have saved for their generations. Recently, crested caracalas was seen on this land. These are endangered species, so instead of saying they're endangered species, people said, well, we just won't call them endangered species so we don't have to worry about preserving that environment. That environment there should be saved, and I applaud Mr. Constantine for his effort to have the money available under the state program used for this. And then I'll just end with Romans 8:20. Creation was made subject to futility, not of its own accord, but by him who once subjugated it. So as we subjugate this land, remember, next generations and many more will be affected by what you people decide today. Thank you, Commissioners.
Thank you, Ms. Creedon. Mr. Abdul-Masai, and then who are the next speakers?
Rosemary Banks, followed by Mary Jo Martin, followed by Richard Creedon.
I'll keep this brief. Isaac Abdel-Messiah, 486 Dogwood Court, Altamont Springs. I'm here today to speak about the wetland intrusion that would occur if the Yarborough property were to be developed over. In addition to supporting this appeal of the approved Yarborough Ranch PSP, I'm presenting you information based upon competent evidence. The Yarborough Ranch PSP, sheet C050 right here, shows various locations where wetland buffers and floodplains will be impacted by the development. LDC Section 5, when speaking about determining development activity compatibility, describes the incompatible use as follows. Quote, building a road through a wetland is one such use which will increase flooding risk because the wetland water flow has been altered and no doubt sediment loss of recharge and pollution to the surface and groundwaters will occur due to the change in the wetland or flood-prone area, end quote. Just imagine what development of the proposed magnitude would do. This impact is largely created due to the increased density of the project and the extended streets. Policy FLU 11.18 and 11.19 both state that road length in rural development shall be minimized, yet looking at this sheet, the road length is significant and as designed is the main reason for wetland impacts. This parcel contains more than adequate uplands to avoid any impact on the wetlands and should not be given relief from complying with the current code. The Yarborough PSP plan should not be allowed to happen since it is not compliant with the LDC because when looking at this sheet, there are various locations that include wetlands, wetland buffers, and floodplains. There is no real reason to allow for lots or streets to be located in wetland areas of flood-prone areas. We must remember our duty to protect the rural boundary. Thank you for your time and consideration.
Thank you.
Rosemary Banks,
Ms. Banks?
followed by Mary Jo Martin.
Okay, Ms. Banks
Okay.
had to go. And Mary Jo Martin? Yours has been covered. Thank you so much. We
Okay,
appreciate that.
So we have Richard Creedon, followed by Philip Graves, followed by Joe Humphreys.
All right, Mr. Creedon, Mr. Graves, and Mr. Humphreys. What did you?
Mr. Graves has left.
Okay.
So we have Richard Creedon, followed by Joe Humphreys, followed by somebody Pickford.
For the record again, Richard Creedon, 1172 Apache Drive, Geneva, Florida. Why is the Geneva Citizens Association appealing the P&Z decision to approve the PSP on December 7th of 2022? One, the applicant currently has vested property rights to construct approximately 174 houses on this property according to the current zoning laws. 300 houses would cause approximately 126 more units to be constructed that would negatively affect the Geneva lens, the bubble. How much extra pumping drawdown can the bubble sustain before Geneva's sole source water supply goes bad from salt and brackish water intrusion? No one knows for sure because the amount of recharge from rainfall is at best an inexact science and guessing game. We do know that any bubble failure would first affect those living nearest to it, who are brothers and sisters in the Snow Hill African American community. What we also know is that if the bubble fails, the county would be on the hook for hundreds of millions of dollars to pump potable water to Geneva. So adding 126 more houses is like playing Russian roulette. Let's not play this dangerous game. Two, the cluster layout of the proposed PSP is not a real cluster in the spirit of that concept. Rather, it is like a standard suburban subdivision plunked down and called rural. Saying so does not make it so. We are not challenging this as part of this appeal, but it does weigh in our calculus. That will be left for a future day and time. Number three, putting 300 houses bunched together on small 1-acre lots in a 5-acre zone is totally inconsistent with the comprehensive plan requirement that new developments in the rural area be compatible with surrounding properties. The Yarborough PSP creates a de facto city in the heart of the rural area. It would be the first and only city in the rural area. How can a new city with relatively small lot sizes possibly compatible with the surrounding properties that are mostly 5 acres or larger? Number four, probably the most important reason, Seminole County has expansive development guidelines in its comprehensive plan and land development code. They both should be followed carefully and to the letter. Failure to do so is a prescription for chaos. If the powers that be do not like any current language, they should work to change it legally. Until and unless the current documents must be followed assiduously so that they mean the same for everybody. Otherwise, you will open the doors to endless controversy and litigation. None of us should look forward to that. Please sustain our appeal to invalidate the P&Z Board's approval of the Yarborough Plan subdivision on December 7th of 2022. Surely a day for resemblance. Sustaining our appeal will buy time to arrange the sale of this property to the state of Florida so the Yarboroughs can be fully compensated for their land, which I'm not finished with the sentence, for their land, which would be then permanently protected for future generations. This land is very much needed for the Florida Wildlife Corridor. Let's all roll up our sleeves and work together to make it happen. Thank you.
Joe Humphreys.
And who's after Mr. Humphreys?
And
what is your name?
Dr. Shirley Pickford.
Okay. Did you hear
So we
that,
have
Shani? I did
Joe
not.
Humphreys, followed by Leon Flowers, followed by Leslie Blackner.
Okay.
Hello again, Joe Humphreys, 883 Cardinal Point Cove, Sanford, Florida. Again, let me once again begin with our Constitution for Seminole County, the comprehensive plan. It's been said here today, we know everybody that's currently sitting on this board and those that you came before you have all campaigned on and stood for the protection of the rural boundary since the very beginning. Going back to 1991, the county's comprehensive plan was amended based on the 91 East Seminole County Rural Area Plan to create the East Rural Area. In 99, the comprehensive plan was amended and to further strengthen the rural character of the East Rural Area. In 2004, I showed you the document was part of the presentation presented by the county as to what was being voted on by the citizens, that it would strengthen and protect the county's understanding of what the rural boundary represented at the time. Not something to be changed in the future, but at that time. So then again, and in recognition of the East Rural Area, the county, quote, "The county shall continue to enforce land development code provisions and land use strategies that recognize East Seminole County as an area with specific rural character rather than an area anticipated to be urbanized." That's your Constitution. That's what you've run on. Everyone on this board has run on this. I can show you those of you that still have your websites up speaks to that today. So that's where we stand. As we've heard today, there's questions as to, and attorneys can debate back and forth. That's why attorneys get the big bucks, because they interpret all of this stuff. Again, what we've heard is that, and in my experience in dealing with these issues, one thing that I've always come to expect, that the people making land use regulatory decisions have an obligation to act in the public interest. Okay? That includes everybody, yourselves, staff, planning and zoning. I would argue that a conflict of interest, and I've said in the meetings with Mr. Chipak discussing these, if you have a person that sits on your planning and zoning board.
Mr. Humphreys, that is not what we're here to discuss right now. It is not.
The planning and zoning.
Your time is up.
One of the reasons
Mr.
that
Humphreys,
we're arguing
your time is up.
We're talking about the fact
We are
that
not
planning and zoning
Mr. Humphreys,
passed this issue.
respectfully, I am telling you, you are off track and your time is up.
The fact that the planning and zoning brought it to this point.
Mr. Humphreys,
That's part of
please
the
do not
process.
make this something it doesn't need to be.
Well, I think planning and
Mr.
zoning
Humphreys, please have a seat.
is part of the process. What part of planning and zoning is not part of the process am I missing?
If I have to ask a deputy to have you have a seat, I will do it.
Leon Flowers, followed by Leslie Blackner, followed by Kim Buhite.
I think Ms. Blackner's decided maybe she doesn't want to speak. Is that?
Leon Flowers.
Oh, Mr. Flowers, are you here? Ms. Blackner, why don't you go ahead and speak? And if Mr. Flowers is out in the lobby, maybe he'll make his way here. You have 3 minutes.
Hello, Leslie Blackner, 300 South Duval Street, Tallahassee. One thing we've seen today is the importance of public participation in land use decision-making. That, again, is the bedrock of land use decision-making. And so many questions have been made as to how density was transferred. The 300 units were gathered onto this one tract. And what I would like to leave y'all with is that Statute 163 states that local planning agencies and local governmental units are directed to adopt procedures designed to provide effective public participation in the comprehensive planning and land use process, and to provide real property owners with notice of all official actions which will regulate the use of their property and affect their property. So many questions have been raised today about how the wonderful deal to put this acreage into public ownership was rushed through and resulted in some problems. And the problems have now come home to roost. I would ask the commission to take a step back and look into what really happened back in 2008 and make an informed decision and determination about the development order, because it is the stool upon which all of this stands, and the stool has some broken legs on it. The 2008 development order has significant legal flaws. It was put into the public records of Seminole County without proper notice and hearing. That is about the most fundamental flaw that a development order could have. And everything that flows out of that development order, including the site plan decisions and any future decisions, are going to be suspect and probably legally questionable. So I would ask that y'all take your time to make this decision. Perhaps put it on ice for a little while and ask staff to make an inquiry. Watch the tape of the commission meeting back in February '08. It will show that there was no public hearing, there was no discussion, there was no debate about the development order or the easement, I might add. Thank you.
So last call for Leon Flowers.
All right. Ms. Holler had her name in to speak at the last one, and she said she'd want to move it to this one, but I haven't heard her name called.
Because she gave her time to Kim Height.
No, ma'am. I'm sorry. It specifically says in our procedures that we cannot give time.
With all due respect, I asked for a form and there were out of forms, and the clerk just gave me the form to fill out. I crossed out Cindy's name, so it's my own form that, I'm not speaking for Cindy, I filled out a form.
Ms. Guevara?
Deputy Clerk Rivero did give forms to 2 people for public comments not on the agenda, and that is when Ms. Bukai asked for a form.
No, I was out in the hallway using the restroom, and I went into the building. There were no forms out there then, and I came in at my earliest convenience, and I asked for a form, and I thought, she was sitting right here, she acted like she was getting me a form, and then she never gave it to me.
There was a form filled out for Ms. Bukai for item number 31.
And 32 originally, but they made me cross that out and said I needed 2 forms. By the time I went to do the second form, there were no forms available.
Ms. Bukai, please.
I could just make a real quick point.
If you would like to do that, let's, in under 3 minutes, that would be fabulous.
Perfect. Thank you so much. I appreciate it. So we heard a lot about the plat of Creekside Acres. Kim Bukai, 6500 Swain Road, Sorrento. I'm speaking for myself. I'm a professional land surveyor in the state of Florida, licensed since 1990. So plats are my business. So we heard from Mr. Chipak, with all due respect, he told you what this says. This document is a 7-page document. I've taped together 2 of the pages to show this parcel, because that's the way my brain works. I have to tape things together like a kindergartner to see it all in one place. More of the plat, more of the plat, more of the plat, more of the plat. So let's look at what Tract 3 really is and was, and how it was legally created in 2008. And I just want to make it very clear that when we talk about Tract 3, we are talking about one very large tract. We are not talking about a subdivided tract with many, many lots. Those lots that you're seeing in the other exhibits, those are coming from the recent application. So I think there's a disconnect about what the original plat actually shows, and I'm just here offering that clarification.
Thank you. All right. Of all of the forms, everybody who wanted to speak has spoken at this point. Ms. Holler, you just said, what is happening?
Oh, you know what's happening.
Yes. Yes, just do it.
Sounds like a Nike commercial.
Yes.
Cindy Holler, 1731 Beacon Drive, Sanford. So, thank you, board, for letting me speak. I appreciate that.
Don't make me regret it.
Unfortunately, I didn't have time to gather documents. Life gets busy sometimes. But I would like to relay my experience as a resident who has lived through flooding on the other side of the county, whose area has been adversely affected by urban sprawl. So, by the way, I am a member of GCA also, and I'm not speaking for them, but I am a lover of rural lands. Development in my area has increased flooding issues because of the elevation of land caused by the fill brought in, probably those trucks that you were talking about, Commissioner Zumbauer, brought in for building without regards to existing neighbors. Engineers plan for a 24-hour storm, but our subtropical climate has other plans, which we saw this past fall. There's been an increase in density in this PSP. Also, traffic congestion, which was mentioned, is an issue on Orange Boulevard in my area and potentially an issue on Snow Hill Road. Please uphold the appeal, and thank you for your time.
Thank you, Ms. Holler. All right, I'm closing public comment at this time. And the applicant would like to come up and do a rebuttal, not another presentation. That would be within your
Yes, thank
your
you.
time.
To address there seems to be a lot of lawyers giving opinions as to the 2008 and notice or not notice. So just a little trip down memory lane. In 2008, what was being approved was not a rezone, wasn't a comp plan amendment, it was a plat. And you all know you've approved thousands of plats within the county. You approve a plat. Your plat does not have a notice provision. State law doesn't have a notice provision for plats. When the plat was being approved, you were not changing any rules that were in place. In fact, I think we had a gentleman pull up your county constitution, which is your comp plan. And that county constitution said then, and it says now, that you are entitled to a rural cluster development. Future Land Use 11.4. Also, as we've discussed, this is allowed in the Land Development Code section 30.109. So you all had a properly noticed plat. It didn't require notice to go out to lots of individuals. It was on the BCC agenda. It included with it the conservation dedication, which was shown to you by Attorney Chippick, and along with that, there was a development order, which I'm sure everyone in here has read it, especially those on the dais. And what it did is it went through and it showed the staff's calculation as to how the 300 units were created under those rural cluster guidelines. There was a concern from the attorney that we're now using land that belongs to the St. Johns River Water Management District. And one thing is already in evidence, and then I'll read you the second one. Already in evidence as part of your staff report is the open space easement, which was executed by the Yarboroughs and the Water Management District February 12th, 2008, and it specifically recognizes the terms and conditions and restrictions of the Seminole County DO and the family's ability to use those upland acres on Tract 3. And then, and I will send this to the clerk, on March 26, 2008, the Water Management District...
Ms. Wilson, I'm going to ask you to move the mountain to Mohammed.
The Water Management District said, "Dear Mrs. Yarborough, on or before February 12, 2008, Seminole County issued the above-mentioned development order relating to tracts 1, 2, and 3 of Creekside Acres, Plat Book 7-4, page 1 through 7. Subsequently, on February 15, 2008, the district purchased tracts 1 and 2 subject to an open space easement from Edward Yarborough Ranches, Inc. In anticipation of future development of Tract 3, this letter shall serve as official notification that any open space credits or entitlements resulting from the replat of Tract 3 should run with, be transferred to, or belong to the owner of Tract 3. Had I known that that was the attorney's concern, we certainly would have provided that letter that was given to the county back in 2008. And I agree that it is a little disingenuous to say that people did not know what was happening at the BCC in 2008. As has been mentioned before, Mr. Creedon wrote specifically to our fellow Genevians. Most of you have probably heard of the development proposal that will be heard by the Planning and Zoning Board of February 6th and the Board of County Commissioners shortly thereafter. In my humble opinion, this proposal is a win-win for the Yarborough family, Geneva and Seminole County. It protects the family's economic interests while preserving forever most of the ranch in an undeveloped state for posterity. Of the 6,400 remaining acres on the ranch, only about 1,360 may be developed, and the family and county have agreed that no more than 300 homes might ever be built on the ranch. Although this total seems large, please understand that if the family has decided to develop the entire ranch, well, upwards of 1,000 homes could have been built, and that is without seeking zoning changes, which could have added the possibility of many more homes. I'm not saying that Mr. Creedon doesn't have the right to change his mind 15 years later about how he feels about this, but I don't think it's the case that people in Geneva were not aware and did not have actual, if not constructive notice. It is not our opinion that actual or constructive notice were required because this was adoption of a ministerial plat. We are here today. I don't think anybody's confused. We know that there were not 300 lots shown on Tract 3 at the time. This is the first part of the process. This is the PSP, the Preliminary Subdivision Plan, which goes to your planning and zoning, which they unanimously approved and has been appealed here. There is still no competent substantial evidence that we don't meet any of the comp plan provisions or land development codes. Yes, this property is Rural 5, Rural 10, A5, A10, and we've complied with the provisions of the comp plan and the land development code in order to properly cluster those. As I pointed out at the beginning, we are not subject to land development code Section 30.109, 30.1088. That is related to land in the Econ River Corridor Protection Zone, which I showed you we are not within. Instead, we've properly submitted under 30.109, and this is in compliance with everything that's in your comp plan to protect the rural area. People may not like it, but we're not asking you to change anything that isn't already there. I appreciate your time today. I think many of the speakers have made it clear that they weren't here to present competent and substantial evidence on this PSP, but simply that they would like this to be a delay tactic, and we respectfully ask for this board to move forward with what the Yarboroughs are entitled to under the law. Thank you.
Thank you, Ms. Wilson. All right. Board members, questions for staff or the applicant or the appellant at this time?
I have no questions. I have none.
You have no questions. Commissioner Zember, anyone have any questions? No questions. Okay. At this point in time, then, we've heard from the public, we've heard from the applicant, we've heard from the appellant, we've closed public comment. It's time to move forward with board action. Commissioner Zembauer.
Thank you, Madam Chair. First, let me say a couple things. I know how emotional this is to many people. You know, I helped run the initiative for the 2004 Rural Boundary Initiative myself. My late wife and I went door to door, went to community meetings, helped put this in place. I receive calls and questions on a regular basis now that people want to call my office and say, hey, there's a small little corner lot in Geneva and they're building a house on it. How come they're able to do that when it's zoned 1 to 5? Well, the reality, and many people don't understand, the rural boundary did not take away rights. It left those rights intact for those individuals it had those rights intact. They were not removed. They didn't lose those rights. If they would have lost those rights, then the taxpayers would have written checks to every one of those property owners that had the right to build on their third-acre lot, their half-acre lot, their one-acre lot. It was from that point moving forward that it would be 1 to 5, 1 to 10. Just a little history lesson. I find it quite disrespectful to the Yarborough family, who, for good argument, if not for them having an agreement with this state, 5,000 acres would still be in their ownership with the rights to do development. If not for the Yarborough family, we would not have that property that now sits there that St. John's brokered a deal on. We can argue it would have been in the best interest of everyone if the entire ranch would have been purchased at that point. And that didn't happen. So here we sat with appeals that I will say, quite honestly, don't have a lot of merit. We've heard a lot of conversation. We've had a lot of allegations. We've had a lot of aspersions. We've even had some illegal opinions that I personally don't agree with. And I'm very sorry for Imogene Yarborough, who has done a great deal for this community, a great deal for Geneva, and had she not been there and her family not been there, there's a lot of things that would not have occurred that this community benefits to this day. Shame on us. Now, we would all love to see something different happen on this ranch. That's not why we're here today, and I think the Yarboroughs would agree with that. We're here today to preserve or not preserve somebody's rights to their property. So with that, Madam Chair, I will move that we uphold the decision of the Planning and Zoning Commission approval of the preliminary subdivision plan for Yarborough Ranch subdivision containing 300 residential lots on 1,313.64 plus or minus acres, zone A5 rural, A10 rural, located on the east side of Snow Hill Road, approximately a quarter mile south of Old Mims Road, also known as item 2023-170.
There's a motion. Is there a second?
There's a second, and I'll second it in the spirit of hoping that others in the future are willing to make similar investments in our community with moving land into conservation and then giving us the opportunity to do something in the future. I think that what I don't want to do is discourage somebody else from doing what was done all those years ago. So with that, I move to second.
So motion by Zembauer, second by her. Any further discussion? All those in favor say aye.
Aye.
Any opposed?
Opposed.
Motion passes 4-1. Commissioner Zembauer.
Thank you, Madam Chair. There was some discussion earlier about, from Commissioner Constantine, about the ability to perhaps talk about purchasing this.
We spoke about a month and a half ago.
Ladies and gentlemen, if you're planning to leave, could you do so quietly because the board is continuing to have discussion that you might actually find interesting?
Might like.
So from my position as the district commissioner, what I would ask my fellow commissioners to consider, we're sort of in a conundrum at this point from the standpoint of there's an appeal process that just happened. There may be a continued appeal process. And the reality is, if there are legal wranglings that are occurring on this parcel, there will be no purchase because you can't clear ownership when there's a legal process going on. So I would move a motion for support only, that our staff be allowed to consider and review and bring back to us the feasibility of purchasing the ranch once and when any appeal process has ended.
Second.
There's a motion and a second.
I concur.
Yeah, I just want to make sure, does the county manager need further clarification on that motion?
I got it. Thank
Okay.
you. Madam Chair.
Yes.
Just clarification. There are several agencies up in Tallahassee that we can definitely work with. We've all had conversations with them. They're very much interested. This land is in the wildlife corridor, so I just want to make sure you're aware of that. If you speak to our state lobbyist, he'll be more than happy to help you with it.
Thank you.
Commissioner Constantine.
Yeah, I just want to be clear, because you said after any appellant process, I don't want to take away anybody's rights to appeal, whatever. I mean, should we not just have them, our staff, start to investigate into it instead of waiting until after any appeal process? Because that could be a lot longer.
So I understand your concern, and I understand, I don't necessarily disagree with that, but I have two things I'm not interested in doing as the motioner. Not wasting staff time, number one. Number two, not delaying the rights of this property owner to proceed any way, shape, or form they are able to under the law. That's simple.
But, Madam Chair.
It's a 30-day deal. If there's no appeal from here, it's 30 days.
Oh, but understand, no matter who appeals, the process of us considering the obtaining of this property should not be affected by any appeal. We can still do that. They could drop their appeal, add their appeal at any particular time. We've got an opportunity right now. There are conservation opportunities with, as I've said, regional entities. We are looking at putting together, our own Seminole Forever. We have the state of Florida right now looking at the possibility of wildlife corridors. I don't think that we should be inhibited by looking into the possible sale simply because of an appeal we can't control one way or another. I think we should really, have the staff. And it's not a lot of time, effort. I mean, this is something that is so important that it shouldn't worry about, the staff working to try to find a way to purchase this property. And I know it's important for the time frame for the Yarboroughs, which I am 100% in support of them being able to sell their property. So I don't want anything to delay the opportunity for us to do this.
Commissioner Herr?
So, two questions. What's the time limit on the appeal, Attorney Chipok? Assuming there's one. Well, there was a time limit thrown out, so I want to validate that.
Typically, it would be 30 days from the rendition of the order.
Okay, so 30 days. I would, as the seconder, offer that there probably would not be that much staff time spent in the next 30 days, and that I would trust the new county manager to be judicious with that. And quite honestly, I would prefer that county staff do the research as opposed to some of us doing it and having conflicting stories up here, because that will certainly delay a purchase and potentially scuttle it. I'll just be completely frank with you.
Agreed.
I need staff that's experts to be figuring out what the funding resources are and how to do it. I do not need the five of us doing that. We need to be governing. They need to be managing. That's my perspective.
And so with that, which I agree, this should be a staff-driven issue. So, yeah, the motioner will accept.
Okay.
And then I'll accept the second of my second that I just, whatever it is we just did there.
So what I'm understanding, to clarify where I think we are, is that there is agreement that staff can judiciously, concurrently, over the course of the next 30 days, begin the preliminary gathering of information.
Yes, absolutely.
Did I put enough adjectives into that?
We can do that.
Okay, there's motion and a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion passes unanimously.
Good.
I think what none of us, well, what all of us want is to have our cake and eat it too. In every area of our lives, right? And we would love to be able to do all the things and make all the people happy all the time. But that's just not where we are. So I think this is a great way for the Yarboroughs to have choices. They can pursue. You have choices now that you might not have had before. So I'm glad we got to this place.
So thank you all for supporting that.
Yes,
very
absolutely.
much.
Thank you. As the district commissioner, I think that was very appropriate. All right. That item is done. If you all want to stay and enjoy the rest of our afternoon, you are certainly more than welcome to. I'm not sure you'll find it terribly enthralling, but you're welcome to stay. We're going to take a 5-minute break while those of you who would like to leave can go ahead and leave, and then we'll resume. reconvene the meeting in just a minute. This is your 1-minute warning. Back from recess and reconvene the Board of County Commissioners meeting at 5:20. We're moving into the county attorney's report.
Thank you, Madam Chairman. Just one item, I just want to clarify from this morning. We had the advertised for the closed session, and I said 2 o'clock in the afternoon. That is because we have 2 workshops in the morning. One is, I don't remember what one is, but the other one is the Seminole Forever. So thinking that will probably, I'm anticipating will be a long one. That's why I had scheduled it for 2 o'clock in the afternoon. If the board wants to reconsider and move it to the morning time, we work at your pleasure.
Okay. All right, well, I think maybe what we'll do is, Commissioner Constantine?
Oh, I'll let you finish.
I was just going to say, what we'll do is we'll look at our calendars. I know Commissioner Constantine and I are both going to be probably trying to get to Tallahassee that night for a Florida Association of Counties event that starts early the next morning. So it may be better for us to try and do it earlier.
Yeah, and Madam Chair, I have to speak to a group there for the Florida Association of Counties that night. So,
Okay.
yeah, so I'm leaving as soon as the meeting's over. I think they've told me they'd like me to be there by 6. So 2 o'clock, it's 4 hours,
Yep.
right? You know how long it is. So if we can move it earlier, I would greatly appreciate it.
Let's work on that if we can.
We can.
We need to advertise that and with a specific time, so
What time what other time can we do?
I propose that we advertise it for 11 o'clock a.m., and then we'll just slide it to the back of whenever the morning session is done.
All right, so would you like a new motion to amend the time?
So moved.
Second.
There's a motion and a second, and does staff have any input?
I was just Melanie Kuntz, Assistant County Manager. My thought was, would it be helpful to do it at 8:30 so that you could be done before the meeting started, and then you would ensure that you had it?
Do you think
My
30
only
minutes
thought.
is sufficient?
I don't know if that's early for you, but
That works. Like I said, we work at your
Madam
pleasure,
Chair,
so.
maybe we shouldn't pick a time and let county staff coordinate on the schedules.
But we have to
That makes them
advertise it.
I don't know,
with
they'll
us.
advertise it.
No, but they advertise what we approve.
well,
Under the
Right.
regulations, I need to announce it
Okay.
today.
What time do you want?
I can't imagine.
If 8:30 is okay with the board, we can do it at 8:30.
Let's make it 8:30.
Move to approve the time and the date.
Second.
Motion and a second. All those in favor say aye. Aye. Any opposed? Motion passes unanimously.
Thank you. We will, it's noted for the record that it's at 8:30, will be at 8:30, and I will do the advertising accordingly.
Great.
Thank you.
Yes, absolutely. Thank you. County Manager's report.
The only report is that I am happy to be here.
Really? After all that, you're
Yes.
you're going to
Yes.
come back tomorrow?
I'll be back tomorrow.
That's awesome.
You met half the citizens today.
Thank you. We're glad you plan to come back. District Commission reports, District 1,
No report.
District 2.
Let's see, just to put on your radar, as your representative on the Medical Examiners Board, there is discussion, actually discussion was pretty pointed about a new ME's office. And we are part of that group for District 5, District 24, and they wanted me to bring back to you all a proposal and commitment to pony up over $5 million to put towards the new ME's office. I told them that I thought it was a little premature because there had not been any capital estimates of what it was going to take to put in the building. And Lake County is proposing to give possibly a piece of property that it could go on, but we're uncertain about that. The bottom line is it was not right for prime time. So we're meeting on April 10th to supposedly have a more direct estimate of what the proposed cost would be. Now, a little back history on that is we've been part of that for almost 5 years. But there was a cooling off period before we actually were allowed to have representation. Under Commissioner Constantine's chairmanship is when our time expired, and as you all know, I was appointed to that board. When I went on the board, they had already been talking about the need to replace the existing ME's office, which is owned by Lake County, had been operated by Lake County. We went there because we left Volusia because of what had happened there. So I'll be bringing that back with staff. The other discussion we had is that our involvement was based on a population calculation as our prop share. That's somewhat problematic if you look at the long term, because the other members of the ME's consortium are not quite developed in their counties. So we're paying based on our population. We're the lion's share, next to Marion County and Lake being second and third. They're going to grow exponentially compared to us. So my concern was, and just put on your radar, and I asked them to consider a different calculation, because when we looked at the services rendered, even though our population was higher, we were using less services, which would arguably mean we're a healthier community. But if we go under the current guidelines, we would be paying a majority share for the new facility. As they continue to develop in those counties, then they would slowly catch up to us, reaping the benefit of our big down payment on the infrastructure portion of that. So I think there's going to be some more conversation going on there. I also am going to be talking with our staff, UCF, as well as Seminole State, to see if there is some other mechanism that's a viable solution for our needs for an ME. It's all speculation, contemplation, just doing due diligence, and I'll bring back everything and all things, including Allison and Melanie, who've been involved in that process and understanding what our options might be. But they wanted us to come with an answer at my next meeting. It's not going to happen. So that's an update on that. Outside of that, there's a letter I think you all received a copy of from the Seminole County Historic Commission, and I think you also received a letter or an email from Mr. Chipak related to the Crow funding that's available. The Historical Society is asking for that to complete their due diligence that they were required to do for the buggy exhibit. If you all have any questions about that, I'm sure Paul can answer those as far as the Crow money goes. So I'd like consensus to bring that forward on the agenda. I'm happy to fill out the proper documentation at a future meeting to have that discussion.
Sure.
I just wanted to make sure, that from what my understanding was, is that, Mr. Chipak, you felt that it was okay for them to use the Crow money for the buggy exhibit as part of it. Is that correct? That was my understanding. I just wanted to confirm that.
Yes. I think the way I stated it was there was no prohibition in the conveyance.
You're doing the negative. Okay,
Yes.
that's fine.
Got it.
I'll second that if that was a motion.
They're going to fill out the form. There's no motion.
I'll fill out the form if it's
Bring it
okay.
back,
If everybody's okay for me trying to get it on the agenda for a future meeting,
I think that's fine.
then I'll move forward with that. Outside of that, everything else in District 2, I think, is okay. I think most of them were here today, or a good portion of them were here today. It's always good to see my folks from the rural area. And also, there's going to be a fundraiser for the Boy Scouts on April 13th, which I am chairing. I hope and look forward to you all having the possibility of showing up. I'll get you information, any support you can give to the Boy Scouts.
Date again?
April 13th.
13th.
At the
Same
Weston,
place?
Weston Lake Mary. So, yeah. It's before tax day.
Yeah.
So, anyway, that's all I have, Madam Chair. Thank you very
Okay.
much.
Great. District 3.
Thank you very much. Speaking of Boy Scouts, I think you saw a young man out there with his uniform on. We had talked about this before. I asked Mr. Wells, who's our retired fire department, and his son, William, if they would like to come and make a presentation during the end of the meeting. Commissioner, you've talked to them. Yeah, I think it was a little bit too late. He had a test tomorrow morning. So although he enjoyed the conversation, he had a test the next morning. But I'm sure at a later meeting, and this is not something that I'm trying to put on the agenda, it's just something they want to make a presentation that we were concerning about the plaque. And as I said before, I don't want to spoil his presentation, but they're willing to do whatever it takes for him to go out and do this Eagle Badge project. And, it just needs our approval, but whatever we say and how we say it, what type of plaque, et cetera, all within all the all of the provisions that we have, they're fine with. But I wanted to let him have the opportunity to do that. So that's coming up. In addition, I did want to say, speaking also of students, I had a on the 17th, I was fortunate that student government at UCF had a How to Get Involved in Government Day. Congressman Soto, former Speaker Christofoli, and myself and others spoke with them for a long time. It was really a nice meeting. It was good to see nearly 150 students out there from UCF that were interested in getting involved in government in one form or another. Also, I just wanted to congratulate not only Altamont Springs. I was at their opening day for their youth baseball, but also I know that many other cities around the county have started their youth baseball. Seminole County has a history of really being successful at that, and I wish all the boys and girls out there that are playing Little League and Babe Ruth good luck this year. And last thing, I think that Commissioner Lockhart and Commissioner Herr and I were at Laura Kelly's retirement for the CFX. As I've asked for, a proclamation for Jim Harrison, I think it's also appropriate that we do something because she has done so much for the community in building the CFX into a tremendous organization. So if that is all right, I would like to move that we have we do a resolution in her honor.
I'll second it. I already have the notes to do it. It was on my list.
Fine.
There's a motion by Commissioner Constantine, seconded by Commissioner Herr, to bring forward through the regular proclamation process something related to honoring Laura Kelly and her time of service to the community.
Okay.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion passes unanimously.
And that's it.
Okay, great. District 5.
I'll just put one item on the list, and I think you're going to cover the second one. That was a nice note to staff. But I would ask that we all keep the Goldsboro community in our prayers. They lost 2 very young children due to a tragic accident. It happened right in front of Rescue Outreach Mission. And I just want to report that Chris Ham has done an exceptional job of making sure that there are counseling services available and after-incident services that are available to the residents, to the staff. We may have had family members that are employed by Rescue Outreach Mission, and he has done nothing but stepped up to the plate in a very meaningful way for the team out there. But do keep that community and the Rescue Outreach Mission team in your prayers. That's it.
Okay. In case I don't say what you thought I was going to say, feel free to jump back in and say it. I would want to give a shout out to everyone who participated and made the Seminole County Garden Expo such a huge success this last weekend. Between our Extension Office folks and 4-H and all of the nonprofits and for-profit organizations that come together to make that expo a reality. It was great. The weather was beautiful, although it was a little warm for February. They estimated over 1,300 people attended. It was just a great day with classes and all sorts of other interesting things to be able to participate in. Also want to thank everyone who made the Rosenwald History Harvest and Barbecue event a success of the weekend prior. We have had wonderful feedback from community members. Thank you to those of you who were able to attend. It was such a treat to be able to walk around this campus and hear former classmates who are now retired share stories and remembrances of what it was like when they were in school there, when they were in grade school, and talking about, you remember Mrs. So-and-so? And there were several sisters whose father taught at Rosenwald, and they all met and took a picture together in front of his classroom door. So the community was very excited to be able to have that time together to reminisce and to fellowship, and they are even more excited about what is to come. And so with that, I would like to talk about the opportunity of utilizing some dedicated funds from some of the monies that we were not counting on that have been recently come through some legal clawbacks, we'll call them, that things that we had not budgeted on that we could allocate toward Rosenwald. I think that community deserves to have things moving forward. We've talked about doing it in a phased plan. There are some funding gaps right now currently. We've all talked about it. We've all said we've supported it, but we've not identified a funding mechanism for it at this point. So absent some other epiphany of a pot of money, I would just like the board to talk with staff and consider what that might look like, how some of those unforeseen funds could be specifically allocated toward Rosenwald. You don't have to respond, I'm just throwing it out there. And that is all I have. So we have future agenda items. Commissioner Delary, Wheatley Acres.
Yes, thank you, Madam Chair. Requesting a future agenda item, I'd like to ask staff to come up to talk about it, give a little more information, show you the future land use and the present land use. Right now, Wheatley Acres is an existing subdivision that is actually zoned commercial, and they would like to be zoned, it's all built out. They would like for their future land use to be low-density residential. And if you look at the map, and Rebecca, if you could just go over that a little bit. They actually came to my office to discuss this. This is right next to one of the apartment complexes. That's why this came up.
Yes. So for the record, Rebecca Hammock, Development Services Director. So the subject property is part of an antiquated plat that was platted in 1957. And the future land use on the property is commercial. The current zoning is A1. However, since it was a plat that was created in 1957, over time, the property has developed as single-family residential. And so the property owners, a majority of the property owners, are requesting that the county process an administrative future land use map amendment and a rezone to change the property from commercial to low-density residential and from A1 to potentially R1, single-family residential. Most of the property owners have provided letters of support for the future land use map amendment and rezoning. Not all property owners have responded to the person from the community that was taking the lead on this request. However, if the board does give direction to the county manager to move forward with this, we would be going through a public hearing process, and there are notification requirements specific to a county-initiated process. And of course, we would be reaching out to the property owners and could even have a community meeting in advance.
Commissioner Zembauer.
I have a whole bunch of questions on this one, unfortunately.
Just
So-
just
Just put it on the agenda.
Put it on the agenda for discussion?
Yeah.
Or for staff to do the work and bring back up? If we're going to have a discussion, I don't know. I've got a lot of questions, and if we're just going to discuss it, that's fine. I won't bore anybody with questions today.
Well, I think the question would be, would this be put on the agenda as an action item, or would it be on the agenda as a discussion item?
And I think that is up to the board. We could bring it back as a work session item or as a presentation by staff, or we could bring it back as an action item, which would be ordinances amending the comprehensive plan and the zoning map.
Commissioner Zembauer.
So that, I'll ask the questions. So what is the requirement, Mr. Chipak, if, I can't see quite how many parcels there are there, but it's 17, 18 maybe. What if one or two say no? Then you have to take out every parcel and only the parcels that agree would be turned over? No. Or the entire plat? And if one parcel owner says, hey, I don't want to do that, can they hold up everybody else?
Well, and Rebecca, correct me if I'm wrong, but way back when we were first doing the comprehensive planning in the state, and comprehensive planning became mandatory, a lot of properties needed to be assigned future land use designations, and then some of them had to be rezoned in accordance with that. So you, as the board, do have the ability to assign future land use designations and zonings to properties even over a property owner's objection.
Understood, and I guess maybe that wasn't the right question. So let's just say the two frontage owners don't agree, and they believe that at some time their heirs in the future may be able to use it for commercial zoning. Do we have a taking at that point?
That's your, it's in your discretion as to whether you want to rezone it or not.
Understood.
Okay. And then once it's assigned what it is, then we can't prevent them from making claims like that.
Sure, understood.
Whether it would prevail, I am not sure. But that would be something that you would need to look at during the process and making your evaluation as to whether you want to rezone the property or not.
And my other question, maybe this is more for the commissioner, is if all these lots are currently already developed, is there some underlying move that we're not aware of that somebody's going to try to take this property? And
To my knowledge, two of the residents came to my office asking how would they go about to change the future land use of this area. I have no dog in this hunt. I just want to present it to the board and present all the findings. I have no predetermined notion, and we'll go from there. I mean, I want to see all the information just like you do.
I think Mr. Gray wants to.
And my recommendation would be, let us bring it back as a presentation to you all, and so let staff and I work with the attorney's office, get all the info, talk with you all individually too, so then we can have a discussion. We have all the facts there as well before we get board direction on how we want to move forward.
Fair enough. Good with that?
Okay with that? All right, that sounds great. Thank you.
It was asked of me by a couple of residents, and I'm bringing it forward per the residents' request. Sure.
Yeah, absolutely. I think that's great.
Flushing it out.
Yeah, that's good. Public comment for items not related to the agenda. I think we have several speakers. Just want to remind any speakers that you have 3 minutes. You state your name and address for the record. And in accordance with the operating policies and procedures of the Seminole County Board of County Commissioners, public participation before the board, speakers shall limit their comments to avoid personal attacks, abusive language, and redundancy. Disrespectful, rude, irrelevant, or slanderous remarks or disruptive behavior may subject the individual to removal from the board chambers. So
Got it. My understanding from Commissioner Constantine is that our first one had to leave.
Oh,
So
okay.
we have Alan Epstein, followed by Dr. Chari.
All right, great. Mr. Epstein, if you would come to the podium.
Yeah, hello, I'm new to the county, a little over a year. I don't need to talk about anything because I've already gotten information from Mr. Delari and someone else to talk to about what I was interested in to help the county with as a new resident in the county.
Welcome.
Welcome.
Where did you move from?
I live in Central Park.
Good. Good to
It's a
have you
joke.
here.
Yeah. Where did you move from?
About 10 miles away in a place called Orlando.
Okay.
Well, we're happy to have
And
you
I
cross
loved
the
it there.
border.
I sold the house to my daughter so she could use it, and I moved to another place that I can use.
Welcome.
And so now I'm going to be in another county. We switched. She was over in Altamont in a small place, so now she's in Orange, I'm in Altamont. Not Altamont, Seminole.
Yeah.
Right.
Well,
Lovely.
welcome. We're
I'll
glad
figure
you're
out
here.
where I am someday.
That's all right. That's all right. Thank you so
Welcome.
much.
Thank you. Appreciate it. I'm raising the population age.
Yes.
Oh.
If you did you write your name and address on that
I did.
form?
It's on the
The
paper.
address is on the form.
Great.
Okay,
Yes.
thank you.
Thank you.
Dr. Chari. Name and address.
Yes. I'm Dr. Sherry. I live at 1911 North Street, Longwood, Florida 32750. Good afternoon. All of you look tired. I don't know whether you can hear me.
We can hear you. We can hear you.
You all want to pay attention. If I were in your seat, I don't think I will last this long. Honorable Seminole County Commissioners and staff, as expected, Hurricane Ian submerged my backyard for about 3 months from the overflow of stormwater retention pond. It wiped out county's remedial road work that was done after the hurricanes of Michael and Irma. The current problems are a direct result of Seminole County's short-sighted stormwater drainage management. In 1969, the county permitted the Florida Land Development Company and others for residential development in this area. An easement was established for stormwater drainage via underground pipe into a spring-fed landlocked pond with no mention of culpability for water pollution or property damage from its flooding. Later, this pond turned into a legal part of my backyard for taxation. Several requests for this pond's maintenance, including flood prevention measures by myself and the neighborhood residents to the county since 1996, were rebuffed on the basis that this is Dr. Shari's private property issue. I felt misled by the county officials during a 2018 meeting that this pond will be included in the improvements maintenance of other ponds located in the Rolling Hills Park development. It did not happen. As a resident and owner of several properties in Seminole County since 1982, I have paid several thousands of dollars toward taxes. It resulted in pay raises for the county officials and the commissioners without me receiving badly needed help. I'm here with the hope that the current enhanced statewide funding for the infrastructure projects will let the county to resolve the pond maintenance problems immediately. I just want to mention that Commissioner Constantine personally visited my property and said he can swim in it, but I can't swim all the time. So I want some relief. Thank you for your patience.
Thank you. Commissioner Constantine?
Mr. Shari, I said a lot more than that, and you know that. We sat there for a long time, and we have had Mr. Dredge, you've been down there. I mean, and we are talking about, I think since I was first elected, we've been, back and forth with this, trying to help. Maybe new fresh eyes, Mr. Dredge, if we could, county manager, if you could ask that we could do that. There is no question, and I've said this before, that Dr. Shari's property, and all of you that have been on North know this, it's at the end of the lot. It gets a lot of the stormwater. I don't know about the underground piping. I don't recall whether we said I'm not saying you're not telling the truth, but I don't remember us saying anything about the drainage pond being done as part of the rolling hills. But I would like, please, that the staff take a fresh look at this. Well, why don't you talk to him first, and talk to the county manager first.
I think we'll have-
No, don't worry about talking to me.
I think we'll have the county manager work with staff and get
Yes.
directly with you, Mr. Chari, if that's okay.
Correct.
I would appreciate it because it has been, I don't know how long I'm going to live. I'm in the 80s. I started my fight since I was in my 50s.
I know this has been going on a long time. Thank you for coming down and giving us an update.
Thanks again for listening to me.
Absolutely.
And thanks again for your patience, and I hope you'll have a good night.
Thank you.
Thank you.
You too. All right, do we have any other comments for the board? Anything else for the good of the order? We'll adjourn the meeting then at 5:50. And I lost a bet by 20 minutes.
So good.